let you know. Just stay in the courtroom if you can. Court, all rise. Hear. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting in Boston within the Commonwealth. Draw near, give your attendance, and you shall be heard. Now take the Commonwealth and Massachusetts. Court is open. Please be seated.
Good morning, everyone. Welcome to the Appeals Court. My name is Justice Peter Sachs. To my right, your left, is Justice Sabita Singh. To my left, your right, is Justice Robert Brennan. We'll be your panel for all 6 cases this morning. If you've been to the Appeals Court before, you know that there are 15 minutes for each side. There's no rebuttal time. The light will turn yellow when you have 1.5 minutes left, and it'll turn red when your time is up. We have read the briefs. We are familiar with the record and the factual and procedural background, so we encourage everyone to get to the heart of your argument right away. And with that, I will call the first case, number 22P446, Commonwealth versus JORGE. I hope I'm pronouncing that correctly. Ms. Varney, if you'll let us know whether we have that pronunciation correct, and we're ready for your argument.
Thank you. Good morning, Your Honors.
Whenever you're ready.
May it please the Court. My name is Sarah Varney, and I will be arguing this morning on behalf of Mr. JORGE. We're here today because Mr. JORGE was convinced to reject a plea and to go to trial on the basis of trial counsel's inaccurate and uninvestigated legal theories. Those legal theories and lack of investigation, unsurprisingly, failed him at trial, and Mr. JORGE was convicted, receiving a 5-year prison sentence, substantially more than the 3 or 3 to 5 years offered by the Commonwealth prior to trial. I'd like to start just by addressing the legal standard here for the ineffective assistance of counsel claim. So this court is reviewing the denial of the motion for a new trial to see if there was a substantial risk of a miscarriage of justice. Typically that means determining whether there was a serious doubt that there would have been a different outcome in that case had trial counsel been effective. The Commonwealth has argued essentially a factual or actual innocence basis and stated that Mr. JORGE, because he is saying that he would have pled guilty but for counsel's inaccurate legal advice, that invalidates his entire claim here. That's not the case. What we need to know is if he was prejudiced and if he suffered some harm from trial counsel's ineffective assistance. What really matters here is that trial counsel and his ineffective assistance deprived Mr. George of an available or substantial ground of defense, and that better work by trial counsel could have afforded him a benefit or achieved something material for the case.
What was the available substantial ground of defense that could have been asserted but wasn't?
So, Your Honor, here that standard is a little bit difficult, or it's a little paradoxical when we're talking about a rejected plea. But effective assistance is required even in the decision whether to accept or reject a plea. So the decision in the defense more substantially was whether to accept that lesser plea.
Okay, so you're not saying that counsel should have done something at trial other than assert these defenses that were unsuccessful?
Your Honor, we're saying that trial counsel should have properly advised his client in the first place. Mr. George was essentially convinced in the face of overwhelming evidence that he had substantial defenses on the two most serious charges. That led him...
Nice. The motion judge rejected that assertion, right? Did not credit your client's affidavit on that issue.
Correct, Your Honor.
Part of that was that trial counsel wrote an affidavit, but it was, 4 lines, and didn't really get into that, from which the motion judge inferred that not much there.
Correct, Your Honor. Trial counsel submitted essentially a skeletal affidavit that said the basics of being an attorney. It's as much as he would need to say for also supporting a guilty plea. But Mr. George's affidavit was detailed. It had complete, concrete, and substantial claims. And those were corroborated by the record. Those were precisely the inaccurate and incorrect theories and uninvestigated theories that trial counsel pursued on the record.
Well, how is it corroborated? I mean, there's nothing in the record regarding what the plea negotiations were, or nothing in the trial record. We know that counsel asserted these theories at trial, but we don't know if that's because he told your client that these were effective defenses, or if it was because he suggested that your client plead guilty, and your client said, no, I don't want to plead guilty, and this is all he had left to go with at trial. Because you haven't suggested anything else he could have done at trial.
Well, Your Honor, frankly, he could have investigated more properly. These legal issues come down to two different problems in the investigation, the advice, the theories themselves. At trial, counsel pursued the theory that he had advised his client of as to the use of a weapon in a felony, and also in the breaking and entering pursued clearly invalid legal arguments, which he had also failed to investigate. So as to that first charge, the possession of a firearm in a felony, he was arguing for use. That is clearly, according to Hines, not what the statute actually criminalizes. So that argument, even on the record, was inaccurate and evidenced a lack of understanding of even what that statute...
Counsel, aren't we back to the place where we don't know whether this was argued because this was all that he was left with. He really didn't have any of these defenses, but it was the defendant who was insisting on going to trial. If that was the case, then you wouldn't have this ineffectiveness.
Your Honor, we still would. Frankly, primarily on the breaking and entering, putting a person in fear charge. There is a moment in the transcript where counsel actually goes back and forth on cross with the complaining witness about the layout of her own home. This is something that an investigator could have been hired to just verify, so that walking into trial, he would at least know the layout of the building that was allegedly broken into. On the at page, I believe it was 143 of the trial transcript, so the testimony day 2. Trial counsel goes back and forth about whether this is a shared stairway or not. The direction of his cross makes clear that he believes that this is a common hallway, common stairway in this building. That evidence is a lack of investigation that was a simple investigation of what was the window actually broken, what door was broken into, how did they access this home, what was the layout of the home. It also ultimately doesn't matter.
This wasn't a part of the new trial, though, or any of the affidavits regarding what counsel's approach was. This wasn't raised below or in your brief. I mean, this is a completely new issue, if I'm not mistaken.
So, Your Honor, this was raised in our brief, and it goes to the same theory that was pursued, that this was a shared stairway, and by whether they entered that or not doesn't matter, because counsel's theory was that because the complaining witness had fled the house, it didn't matter where they were because it was just that back door.
But your theory of ineffective assistance goes to the advice on plea, right? That's where your theory is. It's not as to the...
investigate.
Sorry?
As well as the failure to investigate. We did raise that in our brief.
But it's not, it doesn't go to the performance at trial.
So, Your Honor, the performance at trial further evidences the kind of poorly thought through, poorly prepared theory. And the amount of time that counsel devoted to this shared staircase in this cross-examination and an argument pursuing this theory that because she had fled, the complaining witness was no longer someone present in the home at the time of the breaking and entering, it all goes to that same theory, which ultimately just doesn't hold water.
Can I jump to a different issue for a moment? So the part of your argument deals with the hearing, a motion to dismiss on the discovery, right?
Yes, Your Honor.
And it seems to me that your proposition is that it was improper for the judge to consider the assistant district attorney's assertion that, well, I sent a fax, but I don't have a receipt, so that's on me. Words to that effect, right?
Yes.
So is it your position then that every time there's a discovery dispute, the attorney should be under oath and put on a witness stand?
Your Honor, at minimum, they should be submitting an affidavit if their word is going to be taken, or calling
So
someone
when
from
a
their
defense
office.
attorney says, well, I never got that piece of discovery, should, again, the judge stop the proceeding and say, well, can you fill out an affidavit or take the witness stand, please?
Your Honor, I don't know if they didn't get a piece of discovery, but where there is a court order, as here, and the issue comes down to whether that court order was conveyed and received, then the steps taken to convey that court order are crucial to the issue. I would note here that the Commonwealth's brief at the end of page 22 and onto the start of page 23 actually indicates that an affidavit was filed. It was later discovered that affidavit does not exist. There was never an affidavit filed. There was no statement by counsel, or by ADA Alumba specifically, signed under pains and penalty of perjury.
But again, my question is, I mean, conversations or representations which occur probably hundreds of times a day in the trial courts in this Commonwealth, where one attorney is making a representation about what they did, what they got, what they received, what they sent, and someone else is giving a different position. Is it your position that a judge is either required in those circumstances to require an affidavit or to put the attorneys under oath? Or is it, as I think the Commonwealth argues, well, they're an officer of the court, they're presumed to be essentially under oath?
Your Honor, I would say not in every circumstance, but in this particular circumstance where the conduct of the Commonwealth is specifically at issue and where there is actually evidence that this has happened before, then either, and it doesn't need to be the prosecutor, it could be calling the secretary in their office that manages sending these orders over. But given the fact that there was evidence that this was not the first time, that was in cases cited and acknowledged by the judge, this has happened in that particular court and with that particular lab previously, the order issued and 4 months later, the state police had apparently not received it. The issue here ends up being whether this is mere negligence or recklessness or worse. That comes down to the conduct of the Commonwealth. So that should be something that is actually presented as evidence, be it as an affidavit submitted with their opposition with time to respond, or by calling a witness from the Commonwealth or the ADA's office to the stand. Frankly, the difference between an affidavit and a memorandum is the same between the actual sworn testimony and the argument after it. There is evidence and there is argument, and this should have been presented if the Commonwealth thought that it was necessary and they wanted to present it to essentially lessen the blame, because this seems to be the defining characteristic and the key fact that the motion judge relied upon. They should have presented that evidence in an actual sworn and reliable way.
Okay.
Can I ask? Oh, sorry. Go ahead. Can I ask you about the judge's credibility determinations? Was there something wrong about how he approached the credibility determinations of the affidavits that were before him?
So, Your Honor, I would note on that it was actually not the trial judge that ruled on the motion for new trial. Judge Sullivan ruled on the motion for new trial after the trial was presided over by Judge Moriarty. So in that case... Had Judge Moriarty retired at that point? What was the reason it was sent to Judge Sullivan? I'm not aware of the circumstances for it being provided to Judge Sullivan instead of Judge Moriarty, Your Honor. But it was Judge Sullivan who had not actually presided over the trial. He was not familiar with the parties or the attorneys, he had no opportunity to even observe perhaps the behavior of Mr. George during trial. And yet he, at that point, once Mr. George is seeking recourse for his counsel not serving him, relied on counsel's affidavit, finding that Mr. George's affidavit was self-serving, but counsel's affidavit not addressing, neither addressing nor disputing any of the claims that Mr. George had laid out. That was not, in fact, self-serving.
So what should happen whenever an attorney affidavit is submitted? In all these cases, the preference is to have an affidavit from the trial attorney. When the trial attorney submits an affidavit which sheds no light on the actual issues in controversy, what should happen next?
Then our position is that an evidentiary hearing should be conducted. When it is a claim of ineffective assistance of counsel, that is a serious and critical issue raised by the affidavit. Unless that is somehow contradicted, as it was in Commonwealth v. Dennis, the claims of the defendant appealing his trial finding were clearly contradicted on the record. Here, Mr. George has described precisely the theory that was ultimately pursued at trial, unsuccessfully, precisely the theory that was not fully investigated. On that basis, there was a serious issue or a critical issue raised, and an evidentiary hearing should have been conducted in order to more properly judge the credibility. And while there is additional deference paid to the trial court or to the trial judge if he is later ruling on the motion for new trial, here, this is a judge who had no familiarity, again, with any of the parties and could only go based on precisely what was written on the pages before him and what was in the transcripts. That leaves a lot to be desired as far as any experience with those parties, any tone or behavior in the courtroom.
Is there any case that says that, certainly ineffective assistance is a significant issue, but there's also a question of how substantial the showing was on that issue. Is there any case that says that the defendant's affidavit alone cannot be disbelieved and must be taken to raise a substantial issue if it's not contradicted?
Your Honor, there isn't a case that says that the affidavit must be believed, but Goodrow actually says that it mentions the deference to when the trial court or the trial judge and the motion judge are the same person. But the deference is not enough to get past an adequate documentary showing. Here, again, the claims by Mr. George that he presented in his motion for new trial were concrete, they were substantial, they were corroborated by the theory and lack of investigation on the record, and they were undisputed by counsel. So it's apparent from that there is some issue here. Whether it's an issue that would warrant a new trial is an open question, but the issue has been raised here to the point that it should have been granted an evidentiary hearing. And instead, the trial court relied upon the affidavit of trial counsel who, again, failed Mr. George, and he is the one left to deal with the repercussions. So it was his rights that were violated. It's his rights that he is trying to seek vindication on. And again, he is being denied even an evidentiary hearing to determine the credibility of his claims and to specifically question counsel regarding those conversations.
Just so I'm clear on your ineffective assistance theories, you don't, or the alternative theory, I should say, you don't actually argue that the statutes do mean what counsel argued at trial. Is that correct? You just say if they meant that, then the evidence would have been sufficient.
Correct, Your Honor. The facts came in, for the most part, how counsel expected them to and how he advised Mr. George that he had a defense for. Because of that, they perfectly fit the facts that came in at trial, and the motion for required finding should have been granted if his theories were correct. We certainly do not say that his theories were correct. They were plainly incorrect based on the statutes and case law. But that is kind of the contrast. He would have won if those theories had been correct based on the facts as they came out. Thank you, Your Honors.
Thank you. Mr. Hanson.
Good morning, Your Honors. Arne Hansen for the Commonwealth. Judge Moriarty is in fact retired, and that is why Judge Sullivan presided over the motion for new trial. Does the court have any questions for the Commonwealth before I start? With respect to the first portion of the appeal, the motion to dismiss, that was a Sanford motion. The purpose of that motion is to evaluate whether there was any lost or destroyed evidence. The defendant had the burden there of showing that there was an exculpatory nature of the evidence, was in fact lost or destroyed, i.e., by testing the firearm without his expert present, was there something that was lost or destroyed?
So let me ask Ms. Hanson, let me ask you the same or different version of the same question I asked Ms. Varney, which is, where would you draw the line, if at all, on when and whether an attorney needs to support an assertion or an offer of proof or representation with either an affidavit or sworn testimony?
Your Honor, I stand by what I wrote in my, my written opposition, where as officers of the court, we are expected to tell the truth. I don't think it really matters whether ADA Alumba is standing here or in the witness stand. She's going to tell the exact same story, that she had a fax.
Well, for example, in a motion for new trial, you need either an affidavit of trial counsel, or you need a trial counsel up on the witness stand to provide testimony, right? You don't just have the lawyer stand at the table and say, well, I really didn't tell him that during the plea conversations.
Correct.
So where would, again, what, if you have a sense of it, what's the line, and what are the issues that require it, and what are the issues that don't necessarily?
This is a situation where the court was trying to flush out what happened to the order and why it was never transmitted to the state police lab in order to determine whether or not there was any bad faith. This is very conversational. I believe Judge Moriarty was just speaking with the ADA to get a sense of what happened here. What was this, bad faith? Was it negligence? So I think it's addressing it as they did in the court was completely fine. I don't believe an affidavit or any other sworn statement is necessary where she can clearly just address it on the court, and the court can react and ask questions, follow-up questions to determine what happened.
If the judge then accepts that assertion and makes it part of the judge's findings, factual findings, does that change the dynamic at all, or the landscape?
I don't believe so.
Okay. Why not?
Again, because they're sworn officers of the court.
So what if the ADA had never made those representations at all? If we kind of take those out of the record, did the defendant meet his burden here of either showing, of either part of Sanford?
I think it would be hard to remove the ADA's representations because the first part is, was anything destroyed here? The question was, is this a functioning firearm? The trooper testified that he tested it on that date, that it worked. If there had been any modifications that would have needed to be made, he would have noted that on his worksheet.
Well, that was in the testimony. You don't need the ADA's representations for that. I thought the ADA had merely represented that she'd faxed it, but she didn't stay around to get a confirmation sheet, in essence.
Exactly. So that goes to the second prong, bad faith. I think the only way to evaluate bad faith is to evaluate the conduct of the person responsible for transmitting that order to the state police lab, which was ADA Alumba. So I do believe that a statement from her was necessary in order for the Commonwealth to show that this wasn't done in bad faith, that it wasn't.
Who has the burden of showing bad faith?
I believe in this case, in terms of bad faith, I believe that would be on the defendant, but certainly the Commonwealth always has the burden in the end. Where it's the Commonwealth's actions, I believe the Commonwealth is responsible for demonstrating that it was just negligence.
Could I just ask you to speak a little bit, pull the microphone a little closer?
Oh, sorry.
Thank you.
With respect to whether or not any of this material was outside of the scope of evidence, the defendant relies on Commonwealth v. Hilaire, which is a case with the same judge, Judge Moriarty. In that case, there was a suppression hearing. Outside of the hearing, after the hearing, he did his own research, took census data from online and used that information without telling anyone else involved, either defendant or the Commonwealth, and based his decision based on that census data. Here, it's clearly a different situation. The trooper testified that the firearm was functioning, that there wasn't any modifications that were required, and then ADA Alumba spoke to the court whether or not I don't really believe that whether she stood at the witness stand or was sworn in really matters. She addressed the court asked the questions of her as to why this miscommunication happened. That was all on the record. Judge Moriarty only considered what is in that transcript for that motion hearing. There's nothing to suggest that he did anything else outside of that. So for that reason, I would ask that that portion be denied. With respect to the motion for new trial, the defendant's affidavit is written with the benefit of hindsight as well as the trial transcripts. There is nothing in the record that demonstrates contemporaneously the communications that he had with his attorney in terms of discussing pleas. He can easily write.
What's a defendant supposed to do when trial counsel files an affidavit like this? I mean, the defendant is kind of at the mercy of trial counsel.
That is correct.
Is that fair?
That is the situation that he's in. I can't expect you can't expect every trial lawyer to fall on their sword when they lose a case and to just admit that they were ineffective. I think Attorney Clancy was left in a difficult position. The Commonwealth considered that the defendant didn't have a record. They offered a breakdown, gave him 3 years instead of the min-man of 5. And ultimately, it's a defendant's choice to plead or not. We have a situation here where he chose not to plead because the case went to trial, and Attorney Clancy was left with a very difficult case to try.
But in terms of when he was asked for his affidavit, was he faced with a difficult choice then?
I'm not sure I understand the question.
Well, the defendant's, he clearly had the defendant's affidavit at that point, or must have known what the defendant was asserting, that he'd been advised that he had effective defenses at trial and that he shouldn't plead. So when Attorney Clancy learned that that's what the defendant was saying, why wouldn't the attorney respond to that in the affidavit instead of just reciting kind of blandly, yes, I represented him at trial, yes, there were plea discussions? Why wouldn't he deny what the defendant alleges if, in fact, it wasn't true?
I can't speak to what Attorney Clancy may or may not have been thinking as to why he wrote his affidavit the way he did.
So isn't that then the perfect place where you would request you would have a hearing to flesh it out?
That is certainly a possibility, Your Honor.
So I've never seen it, but there's nothing to preclude the defendant from calling his trial attorney. Usually it works the other way around, but if the Commonwealth calls a lawyer. But, right, you're not aware of anything that would have prevented the defendant from, when he got that 3-line affidavit, from putting his prior attorney on the stand and inquiring if, in fact, there was something there?
Correct. The defendant is only entitled to an evidentiary hearing if they've made a substantial showing. Here, all they had was an affidavit that was self-serving, that was written with the benefit of hindsight as well as the trial transcripts. It's very easy for the defendant to look at the trial transcripts, write an affidavit stating, this is what he told me.
But I guess what I'm asking is, and again, maybe you answer my question, but say the defendant remembers the conversation well and was told, oh, these are great defenses. I mean, go to trial. Don't take this deal. All right? And he's left with this affidavit from his trial lawyer. Is there anything that would preclude the defendant from saying, oh, I want to put that lawyer on the witness stand and have my new lawyer ask questions because under oath maybe he'll acknowledge when put to it that he actually gave me that advice? Or does it
That would be
only go the other way?
That decision essentially lies with the motion judge.
Right.
That would be Judge Sullivan's decision. He would weigh everything in front of him. He would weigh the Commonwealth's motion as well as the defendant's motion and see if there was a substantial issue that needed to be flushed out with an evidentiary hearing.
So is this a better case for the defendant to get an evidentiary hearing if the trial counsel had not filed an affidavit, or is it a better case for the defendant with the affidavit? I mean, what is the judge, does the judge look at trial counsel's affidavit and draw any conclusions from it or make any inferences when the judge decides to deny an evidentiary hearing? And if so, what were those in your view?
I argued the motion of trial for the Commonwealth, and I remember standing in front of Judge Sullivan, and as he reviewed the Attorney Clancy's affidavit, I remember him stating that that affidavit was not very helpful to the defendant's cause. Did
it hurt it? I mean,
I suspect it did where it didn't support the defendant's claims explicitly.
Well, but why wouldn't it have contradicted the defendant's claims if, in fact, Attorney Clancy's memory was that he had never advised the defendant these were good defenses and he shouldn't take the plea?
Again, I can't speak to what Attorney Clancy may have been thinking. As someone who is a private attorney, as Attorney Clancy is a private attorney, it might make sense for him to not immediately stab his clients in the back when the cases go south. There's a bit of a conflict of interest there. He might not get further employment if he goes against his clients in post-conviction proceedings. He might develop a reputation. I suspect that might weigh on the mind of many defense attorneys. But again, that's speculation. I don't know why Attorney Clancy wrote what he did. It's possible that he doesn't have a memory of what he advised the client.
But he didn't say that. We see plenty of affidavits where attorneys say, I have no clear memory of what happened. I do not remember any discussions. He didn't disclaim, memory.
Correct.
So what's the inference? What's the logical inference to be drawn from an attorney who does not speak specifically?
I would suggest that he disagrees with what the defendant has written, where he doesn't want to support his client. If there was an actual issue, why wouldn't he support his client? I think ultimately it's a conflict of interest for him to write something that is an opposite to what his client is saying, because he does make a living off of representing people. If he throws his clients under the bus, he may not get. That's going to certainly affect his income stream.
And on the other hand, if he does support his client position, that he's acknowledging ineffective assistance.
Which would also hurt his income stream, because then he's saying, yes, I was ineffective, which would hurt his ability to get future clients as well. So I think he's in a position where the best thing to say is nothing. He's either throwing his clients under the bus or he's throwing himself under the bus. If he says nothing, it stays neutral.
So then what's the solution? Is the defendant just stuck with that?
It appears to be the case.
Is that a fair way of resolving ineffective assistance claims? So the defendant doesn't get an evidentiary hearing in this situation?
Where he failed to raise a substantial issue. So in Walker is a case very similar, where, again, they disputed whether or not there was enough evidence to support that the defendant relied on his attorney's advice to not plea a case and take it to trial. In that case, the defendant offered contemporaneous communications. So I believe the plea occurred in January in that case, and he had a letter from his attorney concerning the legal advice regarding whether or not to plea from October. So there was a contemporaneous record prior to the plea as to what advice was given. That conviction was still affirmed because of the 3-month span in between the plea date and the date of the letter. The court felt that there would have been additional communication between him and the attorney that the defendant did not bring to light, and they ultimately did not accept the defendant's argument.
And what was the time period here?
It's unclear. The defendant's affidavit gives no time period, doesn't give any details as to what was actually discussed. He states that he discussed the defenses, but in his affidavit he doesn't specifically state these were the defenses that I discussed. He just states we discussed the defenses and I decided to take the matter to trial. It is in the defendant's memorandum that it goes deeper into what those defenses were, again, relying on the transcripts after the fact.
What was the time period between the conviction and the filing of the motion for new trial?
In this case,
Yes.
I believe he was convicted in 2017 and the motion was filed in 2021. Or he was convicted in 2019 and the motion was filed in 2021. If I may have a moment, I can check in my brief. He was convicted in December of 2019. I know we argued the motion in May of 2021. He filed a motion for new trial.
And how long was that after appellate counsel was appointed?
I'm not sure.
Okay. All right.
Thank you.
We can find that. All right. Thank you. Our next case is number 22P521, Commonwealth versus Austin Mendes. All right, Mr. Brooks, whenever you're ready.
Good morning. Thank you. May it please the court, my name is Stephen Nato.
Oh, I'm sorry. I apologize, Mr. Nato. Yep, Commonwealth's the appellant.
Didn't even hear you. I'm Stephen Nato, Assistant District Attorney from the Bristol District, arguing on behalf of the Commonwealth. We're here today on an appeal from the New Bedford District Court allowing the defendant's motion to suppress as to 2 search warrants. In this case, there were 3 total. The first one was upheld and its validity is not challenged here. And then the third one was invalidated because the second one, the judge determined did not establish probable cause. Obviously, our position today is that the warrant application did establish probable cause to believe that evidence related to the apparently substantial criminal operation happening in the bedroom of, or basement rather, of 206, 208 Sycamore Street. Further evidence of that would be found.
Nato, can I jump right in? Let's say the chop shop was around the corner.
Sorry?
Let's say the chop shop was around the corner, in a garage or a warehouse around the corner. Do you get to go into the guy's house?
Well, we don't know where the chop shop is.
Okay, let's say that they're disassembling motorcycles and having packaging materials for shipment overseas 5 blocks away or across the city, as opposed to in the basement,
So
of a or 2-family house. That's my question.
yes, then I think the Commonwealth would have a real problem on those facts. But here, given that then what's the connection to either of those residences at 206, 208, if the bike and everything else is found some distance away?
If the person who's running the operation, at least in theory, or who claims, well, that's my bike, and around the bike are things that appear to be what one might use to disassemble it and then send it overseas. So that's the person responsible. Kind of like the alleged drug dealer who's selling drugs across the city and lives in an apartment somewhere else.
Then I think you would need additional facts connecting to the residence itself, where if he's not observed kind of carrying things from one to the other, what is the connection?
Right.
Here, of course, the connection is that it is the basement of the residence. And there are 2 apartments in that residence, 206, 208. One's a defendant, one belongs to someone not disclosed in the, or not named in the affidavit. And so an inference that I acknowledge would fall apart if you start to add a 3rd apartment, a 4th apartment, and so on. But here, there's a pretty solid basis, given everything that's down there, that whoever is working on this bike is apparently part of this kind of complicated, ongoing operation, is living in one of those 2 residences.
Why is that apparent, that who's ever down there is part of a complicated, ongoing operation? What is there to connect this particular stolen dirt bike to the ongoing large steel and cell ring that the...
That, I would say, would be the informant who...
But does the informant say, I know where a stolen bike is and it's part of this ring that you're investigating, Sergeant Robert?
Well, I don't know if he puts it in those terms, but he does describe, we break them down, sell them apart, and ship them overseas. And then...
Where, maybe I missed that, where does the search warrant affidavit suggest there's any tie between this particular stolen dirt bike and the larger ring?
Well, they run the VIN, and that dirt bike is stolen, and I believe it's a separate dirt bike that the informant has told them that he had brought to the basement, the one that was stolen from 1297. He had the GPS. They spoke to him. He says, yes, I initially denies it, but then says, yes, I was there for that theft, and I brought it to this residence, I believe, and where it's in the basement, and I believe that's a different VIN, or a different bike than the one that's found in the basement. But certainly, I would suggest that even if my recollection is wrong there, the fact that as this is contextualized by the detective as part of a ongoing, at least 18 months, complicated investigation into
A coincidence in time doesn't necessarily tie this particular stolen dirt bike to the larger ring, does it? I mean, I think it does make a difference. You've got a stronger case if there's some evidence that this bike in the basement is part of a larger scheme.
Well, I think that, the fact you have the industrial shrink wrap down there. You have the pallets, you have the tools. It seems like there's a more substantial setup down here than just we're only dealing with, coincidentally, this one dirt bike that has been reported stolen. So I think all of those things taken together establish that it is part of that larger operation. And then you have sort of the unique circumstance of this duplex where, stands to reason, common sense inference that someone who lives here is carrying on the operation in the common basement. Usually
Stands
someone's
to
doing
reason?
Sorry?
Just stands to reason?
Sure, I think that's the common sense, how are basements generally used even in multi-family buildings by the people that live there. I live in a 3-family building in Fall River. If someone's in my laundry room, I make a pretty common sense inference that they live in the building.
But if there was stolen, and I don't want to get personal, if there was stolen property in the laundry room and all sorts, or let's say there were drugs, drug operation in the laundry room, you're not taking the position that the police then have probable cause to search all 3 apartments, including whomever's? Let's just put it that way.
No.
Okay,
no.
so what's different here?
And again, we are now here with the only 2 on it, sort of which one is it? And then I would suggest that's where the defendant's, at first, his statements kind of shed light on that one of 2.
I mean, the which one is kind of important. I mean, without getting into cases in the past where they have the wrong which one and the police go in and put people at gunpoint and things of that nature and they have nothing to do with it, right? So that's kind of an important factor.
I agree. I think that's the critical question here, and I think that's then what comes later. And that is where, at this point, they make their observations. They now place the defendant in handcuffs and bring him downstairs, put him on a couch in the basement, and they ask him, do you know about this bike? Yes. Do you have the registration for this bike? No. And certainly it doesn't amount to a confession on its terms, and it would be one thing if he stayed silent totally, but he has spoken, and the sort of caginess of that response, as opposed to, if you're asking about you're asking me about, in my building, are you aware of this bike and it's not mine? I say, yeah, I'm aware of it, but that's so-and-so's on the 3rd floor, or so forth. And the fact that in response to that initial first question, he merely says, yes, I know this is down here. And then this follow-up question, do you have the paperwork for it? No, as opposed to, no, why would I? It's not even, it's the other guy's. It belongs to the other guy, or belongs to someone else. His simple kind of caginess there, I think, is suspicious, and sort of, to the extent that this is sort of a case that could be decided on the margins, shades the overall observations that, okay, we think this guy is now connected to the dirt bike based on that affirmative response, and then based on our observations of him putting the key into the door of the one particular apartment, checking it on the way around back, that is his apartment, and that things that we might expect to be down here as part of the ongoing operation that we didn't see, some of the manifests, shipping labels, they had the stuff to break it apart, but how do they then transport it out?
It just seems to me there's so many inferences. Because he puts his key in a particular door, the assumption is that's his. I mean, we don't know his relationship. Maybe he's got keys to all the apartments. Maybe he's the caretaker of, So there's a leap, without any additional information about him, about who's in these other premises. Then there's, okay, he's got access to the basement. We don't know who else has access to the basement, or the fact that it's being used for a particular purpose, but that doesn't necessarily, there's just too many inferences that the Commonwealth is seeking.
Yes, and certainly there is a chain that we're relying on here, but I would submit that it is a reasonable chain of inferences each step of the way.
Can I ask
I'm
sorry to finish, please finish.
Just to finish quickly, putting the key in the door, that, I think, a common sense inference, that is probably his house if that's where he's going into it, apparently to let himself in. And, Commonwealth versus Andre Field says we don't have to exclude every innocent possibility.
Okay, the last inference, okay, so you have all of those, that's his apartment. Because you have these things in the basement, there's a logical inference that there's more related to this operation in the apartment?
Yes, because of the nature of what we know about this particular operation, that it's not just we break this stuff down and then it goes somewhere else, but it's that we break these into parts and then it's shipped somewhere. So we have some stuff that would go along with that. The industrial shrink wrap would be part of it.
What would you expect, if that was in the basement, what additional would you expect to find in the apartment as opposed to in the home, the residence, rather than the basement when the operation is going on there?
That's where I think the shipping labels, anything like manifests or records or, proceeds, funds.
Was
comes
that
from it.
all listed?
Sorry?
Was that all listed as being specifically requested?
Shipping labels, manifests, things like that were listed. I don't know if they said proceeds from it, but that was part of what was sought for in the second warrant.
So it seems to me the natural analog, and most of the nexus cases are on drugs.
Yes.
Okay. I looked, I'm not sure I found that was close, but what's the best case that you can cite where you had drugs or even a drug distribution paraphernalia in the basement of a multi-family, and that provided a nexus to one of the apartments without more? Is anything even close to that?
I don't have anything.
I assume you looked for them and would have put it in your brief if there was something that you could have found.
Yes. And again, that may search, but I do think that, again, here that might depend on if, it looks like a meth lab being carried out in the basement as opposed to, is it just a little bit of crack or a crack pipe or paraphernalia, things like that. It would depend on, again, the size, the scale, the complexity of the operation. And
I guess what I'm looking for is the logical inference that then ledgers or cash receipts or cash itself would be found in a separate place, even within the same premises.
Yes, I think that's logical because where it is being carried out at a residence, it is natural to, I think, infer, it's reasonable to infer.
That usually explicitly set out in the affidavit. In my experience, I've been involved in these investigations, and the paperwork is kept separate from, that's what we see in the drug cases, if a large-scale drug case.
And that may be sort of inherent in the sort of unusual nature, like as Justice Brennan mentioned, a lot of these cases are drug cases. We don't have a lot of steal and sell cases for, what in our training experience we expect to find hidden where versus where. So we're sort of not in an entirely different territory, but it is just a different situation where he may not have that particularized knowledge. But again, as opposed to a otherwise professional or separate location, this is the basement of a residence with only 2 apartments above it, and the reasonable inference from that is someone, given the scale of this investigation, is probably carrying it out from one of the 2 residences above us. And then it's the statement the defendant makes, the statements he makes while handcuffed, that in such a scenario you would expect something different if he's going to say anything about it at all. And then their observations of him around that particular apartment, I think, establish probable cause in this case. Again, I see I'm sort of running out of time here.
If this were a single-family house, do you have any case suggesting that finding something in the basement could warrant searching the rest of the house?
Nothing particular, but I think at the point you're getting to a single-family house, if you have evidence that they're, doing a large-scale operation out of the basement, you likely have probably a nexus as to the rest of that single-family house. And that's part of why I mentioned the sort of inference we're urging here, where you sort of start with kind of this either-or proposition. We're in the basement based on these observations, which of the 2 apartments above us is connected. And then that starts to become more attenuated as you add a 3rd family, a 4th apartment, 5th, a high-rise. That would probably be a basically useless inference. But here, where you are beginning with a sort of closed universe, only of 2, I think the facts here shade it in the direction of the defendant's apartment, establishing probable cause. If there are no other questions, I would rely on the brief. Thank you.
Seeing none. Thank you. Now, Mr. Brooks.
Good morning, Your Honors. Thank you. So Mr. Brooks, on behalf of Austin Mendes, may it please the Court. So I think there are really two major flaws here. Obviously, this is a nexus argument, but I think it even starts before that because there's no real link between Mr. Mendes and the stolen bike in the bottom. And then even if there had been, of course, there's no reason to believe that any evidence of the stolen motorbike or that operation is going to be found in his apartment. And I think when you listen to the Commonwealth's argument, it sounds like reasonable suspicion, right? It does not sound like probable cause. And I don't think they ever really advance beyond that reasonable suspicion.
Well, you've got his access to the basement and then his admission of knowledge.
Admission of knowledge that there was a motorbike in the basement and that he didn't have paperwork of it. Right? It's not even an admission that he knew that the motorbike was in fact stolen. And I think when you look at the detective's affidavit and he says, look, these bikes are bought and sold so frequently that it's very hard to track down who they actually belong to and whether they've actually been properly accounted for. So it's like the CI says the last place this motorbike was in the basement of this, and maybe this person was going to sell it off, but it's very hard to say that was part of the ongoing operation. And then when you get to Mr. Mendes, where is the information that he was the person that the confidential informant was referring to? All we know is that Mr. Mendes was present when the police came with a search warrant, that he lived apparently on the first floor apartment, and that more than one of the apartments had access to the basement. And when the police asked him if he was aware what was in the basement, he said, yes, I'm aware that's there, and I don't have any paperwork for it.
So no issue with the, at least in context here, with the reliability of the informant?
I think that was an issue that was raised in the court below, and I didn't argue that here.
And basis of knowledge says he was there, so not an issue there.
I don't see any argument on
So
that
I'm
point.
looking at the October 17th affidavit, and the informant indicates that one of the bikes is being disassembled, sees it in parts being placed into shipping crates, and then says that the Honda would be broken down in a similar fashion as it would be prepped to be shipped overseas, and similar stolen dirt bikes are brought to this location. So, right?
Well,
So
yeah.
doesn't that at least give the police probable cause to believe that that bike was going to be broken down and then taken apart to be shipped overseas?
Yeah, I suppose. I think there's one argument that maybe not, because the bike was stolen, I think, in early September. It's October 17th when they come to this location. It's in pristine condition, right? So I don't know that there's any real inference that this was about to be broken down. But I don't think that's the real gist of the argument.
Let me ask you this, what significance, if any, does it have that the police see several rolls of shrink wrap next to the dirt bike, those words next to it, and then small pallets? I don't know where the west-facing foundation wall was, nor any of us do, so that's fine. But then a toolbox with tools next to the dirt bike. So you have tools next to it, you have shrink wrap next to it. Doesn't that give you enough at least to have probable cause that that dirt bike was next up in the line to be stripped down and packaged up and shipped overseas, or at least its parts were?
I think you might get to the reasonable suspicion of that. But I don't really want to focus on that if you were inclined to find that that was enough for probable cause, because I think the real gist of this argument is that even if that were so, right, even if the police could determine that this bike that was found in the basement was about to be sold or shipped off and broken down and sold, where is the evidence that Austin Mendes had anything to do with that? Apart from the fact that Austin Mendes lived in the apartment above there in a multifamily dwelling and happened to be home when the police came. So, this is an...
Yes, Mr. Brooks, what if we reverse it? What if we reverse it and they have, again, presumably probable cause to search Mr. Mendes' apartment, and then they see he's got a key to go into the basement? Does that change it at all, the analysis?
Well, I mean.
No, there are curtilage cases, but I'm not sure that, but
Yeah, I mean, if he had, I mean, then it's just a question really of, yeah, that's a question of curtilage. Does he have, does the basement fall within the curtilage of the house? Is the basement specifically described as a place that the warrant covered, right? Or would they need to get a separate warrant for it? But here the question is, does the fact that Mr. Mendes lives above a basement that has a stolen motorbike in it give the police probable cause to search his apartment?
I guess that's my question, because they do get a search warrant. The question is whether it's a valid search warrant. So say the flip of it, which is that they have probable cause for his apartment, and then they see him going into the basement with his key to the basement, and then they go and apply for and are issued a search warrant for the basement.
Right. I mean, I just think that,
You see, there's a nexus. Is there a nexus there that's sufficient to satisfy
I mean,
the
it
standard
depends
here?
on what they're looking for, right?
Same
And-
thing. They're
yeah,
looking
yeah.
for packaging materials that may be stored in the basement. They're looking for receipts from bikes. They're looking for all sorts, all the various things that they say they're looking for here. We've just flipped the locations.
Yeah, no, I mean, I haven't thought about it that way, I have to admit. And I don't think that, it's, the apartment gets better protections, right, than a shared basement. That is certainly true, right? And I think that there is, if there is criminal activity that is going on in a shared basement, there is less of a likelihood of evidence being found in the person's residence, even if it is in the same building, than vice versa, right? I would say that. But I do think that it is important just to remember that, this 18-month investigation, there's no mention of Austin Mendes, right? The confidential informant never mentions Austin Mendes. He never gives any description of somebody who matches Austin Mendes's description. Nobody does. Nobody in this entire investigation. And the detective said that he had been involved in the recovery of numerous bikes. Mr. Mendes never comes up. The only time this address comes up at all is when the confidential informant mentions it, and it's the shared address that he's mentioning. It's the shared basement that he's mentioning. He never says the person who is responsible for keeping this motorbike is the person who lives at 208 Sycamore Street. He just mentions 206, 208. And then there's something that I completely missed, which is that these statements that they took were in violation of his Miranda warnings, apparently, because at least there's nothing in there that says that that they gave him his Miranda warnings before he made these statements. But even with those statements, all he's doing is admitting that he knew that a motorbike was there and that he didn't have paperwork for it. And I think when the Commonwealth says that there's sort of this caginess of his response because he doesn't say more, I think, that's a suspicion, right? But that doesn't give you a probable cause. And then, so, they fail on the first prong to even show that Mr. Mendes, that there's probable cause to believe that Mr. Mendes was involved in this operation. And then the question is, of course, even if there had been, is there probable cause to believe that any evidence of this operation is going to be found in his apartment? And I find it kind of problematic that the Commonwealth wants to argue that Mr. Mendes' sort of efforts to protect the police from entering his own apartment somehow makes him suspicious. I don't think we can do that, right? He has a right to keep the police out of his apartment, and the fact that he wanted to do that doesn't make him any more suspicious. Otherwise, we wouldn't, it's sort of...
Are we accepting that it's his apartment, to Justice Singh's earlier question?
I don't think that there's a real argument that he didn't live there, right? I don't think that's... I think the record established that he lived in that apartment, or that he had at least some connection to it. I think that the real question is why would you think that there'd be any evidence of this motorbike operation in his apartment? And, this is where you get back to the standard. You were very used to distinguishing between reasonable suspicion and probable cause, but here it really matters because you have to have that substantial basis to conclude that the evidence will probably be in the place to be searched, right? Strong suspicion is not enough. And I like the language that I cited in the brief from Commonwealth versus Broom, which is It's not enough to say that the object of the search may be found in the place subject to the search. Rather, the affidavit must demonstrate that there is a reasonable expectation that the items will be found in the located in the particular place to be searched.
But that's still not a preponderance.
No, but it is more than just merely speculation. And I think what the Commonwealth is asking for here is pure, sort of purely aspirational. Oh, there might be some receipts, right? There might be some shipping labels.
Is it logical to think that there would be receipts or shipping labels somewhere?
I don't see anything in the affidavit that suggests so. And then also
Well,
you have...
as a matter of common sense, you usually need a shipping label or some kind of paperwork if you're sending something overseas.
Yeah, but why would you expect, first of all, that would be in Austin Mendes's apartment, right? If this was this big...
Somewhere on the premises.
Well, if this was this big, broad operation that they're saying it was, it seems like one person does the stealing, one person does the breaking down, another person does the shipping. Where is the evidence that Austin Mendes was responsible for printing shipping labels, right? Or where is...
Is there any evidence that another person does the shipping?
There's evidence that this was this broad operation that involved a whole lot of people, right? And it didn't seem...
Nothing about the structure. There's no reason to think you've got one or more people stealing and then one person doing the shipping.
I think that there's a suggestion here that there's somebody steals a bike, somebody else breaks it down, and then it gets shipped out. And if that's lacking in the affidavit, that's on the Commonwealth.
So if there are pallets and shrink wrap, industrial-sized rolls of shrink wrap in the basement, doesn't that suggest that at least some part of the shipping is being done from the basement?
The breaking down, right? But not necessarily taking it, printing out labels and shipping it
At least the
somewhere.
packaging.
Yeah, the packaging, right? But and you know, the police could have done some surveillance. They might have had a situation where they sort of saw some activity going on that suggested that this actual, that there would actually be more evidence of this operation in the apartment, but they don't, right? And I think that the cases are very clear that, you know, evidence that somebody is engaged in criminal activity on its own isn't enough to search their apartment. And as Justice Brennan pointed out, most of these cases happen to be in the drug context, just because that's where they go. And when you look at those cases, I think you always have some other kind of plus factor, right? Even the ones that don't involve drugs, like Commonwealth versus Cavett, which is, I think, an assault case or a murder case. It's, you know, there's probable cause that the defendant committed the crime. What gives you the plus factor to search their house? Well, it is that they were described by the victims wearing a very particular item of clothing, and it's reasonable in those circumstances to say that that item of clothing will be found in their apartment. We don't have anything near that here. In the drug cases, you have all of those cases where you see the defendant leaving his apartment, going to one transaction, coming back. That's not enough to search their apartment. You have to have some plus factor. What do the police look for? They look for a statement from the...
If this were if this were single family, would you need a plus factor?
I think that makes it better for the Commonwealth, certainly. I still think you need something else to get into their residence, right? But it's not a single family, right? It's a two-family. And there's no information here that Mr. Mendes, as opposed to the occupant of 206, was the person who was actually engaged in this behavior. All you have is an admission that he knew about the bike and that he didn't have paperwork for it. But that's not enough. And even if it had been, why do you think that he would be keeping additional information or additional evidence in the apartment? I think that the defendant's memo in support of his motion in the court below said it well, which is the police found everything they were looking for when they got there and searched the basement. Why would they think that there was anything else? And I think when you add on to that the fact that they really had very limited amount of information that Austin Mendes was involved, no concrete evidence to make the probable cause inference that there'd be any other evidence. It's just speculative hope, right? Maybe there would be, but that is not the probable cause standard. And I think that, you know, I sort of broke this up into, you know, commission and nexus, but really this is all part of the nexus, because the relative weakness with which they've identified Austin Mendes as a potential culprit here is part of the overall probable cause analysis. It's so weak, right? And then, on top of that, there's no concrete fact from which you can make a reasonable inference that any other evidence of this crime is going to be found in the apartment.
All right, seeing no further questions, thank you both for your arguments.
Thank you very much.
Our next case is number 21P679, Commonwealth versus Robert McGillivray, and we do expect to be taking a 15-minute break after this argument. Ms. Contertesi?
Please the court, Adriana Contertesi for the defendant appellant Robert McGillivray. Mr. McGillivray asserts that his conviction should be vacated for insufficiency of evidence of intent, or in the alternative, that his conviction be reversed and he be granted a new trial that's a fair trial. And I have 3 reasons in support of these assertions. Some of them have a few little sub-issues. The first reason is that, as contrary to what my sister asserts in her nicely written brief, Mr. McGillivray was entitled to that instruction because
Excuse me,
there's
just
no way.
which one? You're talking about what we used to call diminished capacity?
Yes, short of insanity.
Right, yep,
One
mental
that would
illness.
vitiate the intent.
Right.
He was entitled to that instruction because there's no way that threats to commit a crime is not a specific intent crime.
Do you have any case that says that?
Sure.
Sorry.
Look at Commonwealth versus Ezekiel James. I have the citation. That's an appeals court case. 73 Mass App Court 383. That's 2008. It's still good law.
Can you, one more time on that? I'm sorry.
Ezekiel James. Last name is James. Justice Graham wrote the decision, I think.
Okay.
In Commonwealth versus Ezekiel James, he had written some letters to another friend of his who was also in the Suffolk County House of Correction, soliciting him, because he was soon to be released, to kill his ex-girlfriend. And Mr. James, once the letters were found by prison officials, Mr. James was charged with threatening to commit a crime as to the girlfriend. And that conviction was vacated because the intent required for threats to commit a crime is it has to be intended to be communicated to the victim, either directly or by communicating it to a person that defendant knows is going to communicate it to the victim to whom the crime is intended. So, threats to commit a crime, I don't understand why the trial court rejected the idea that threats to commit a crime is a specific intent crime, because without that intent, I mean, there's no way threats to commit a crime is criminally negligent. I mean, if you're just making threats out into the open air, it's not a threat to commit a crime.
So a general intent, for example, in assault and battery is an intent to do an act toward a particular person, right?
Oh,
so it's
yes.
not out in the air, it's not negligent, but it's not specific intent either.
Not an intent to do an act to a particular person, but the intent that threat be communicated to a particular person.
Okay.
It's the intent
where in
to
Ezekiel-
have it communicated.
Oh, sorry. Where in Ezekiel James does it say that there's specific intent? I see that you were counsel in that case. It wasn't cited in the brief, so we're not immediately familiar with it, but just scanning it quickly, I don't see the word specific in there.
No, there wasn't. But where is there going to be a case where a court spells out the specific intent? They're going to tell you what the intent is. Well, that's the specific intent. You cannot have a conviction for threats to commit a crime unless you have that element of the intention that threat be communicated directly to the person to cause apprehension. Doesn't matter if the person winds up in apprehension, but that has to be the intent.
But that goes back to general intent.
No, it doesn't, because if it's general intent, you're just communicating a threat that is not directed to a particular person, and it's nothing
Well,
more than
you're intentionally
negligence.
communicating the threat, but it's still a general intent.
No, the intent is that it be communicated to a particular person. You're not standing in the back of the line saying, boy, those people up there, you know, they're really.
So was there an issue in this case about communicating the threat to the police?
Well, the issue was, is the defendant entitled to that particular instruction of incapacity short of insanity? You only get that when it is a specific intent crime, because what mental incapacity short of insanity does is it vitiates that intent element of the crime. And that leads me to my next point, which is that the instruction, which was incorrect, created a substantial risk of a miscarriage of justice for a few reasons. Well, the first reason was that it was flat out wrong. As of 2016, that particular instruction that says you may take into account that the majority of people are sane, that is not supposed to be given as of 2016 in Lawson. And the effect of that instruction does a few things to really prejudice the defendant. The first thing it does is it creates a rebuttable presumption, really is what it does. So you're not starting off with a clean slate for the jury. This jury is starting off with the slate of, well, the Commonwealth has to rebut this presumption of sanity. And what does that do? Well, that violates the defendant's due process right to prepare and mount a defense. If he had known that he was going to have to, if he was going to have to withstand a rebuttable presumption, he would have prepared more. Secondly, the evidence was really not that strong. The reason why the evidence of insanity was not that strong, and there are cases that say, yes, the instruction was incorrect, and I think my sister's brief cites those cases more. Lawson, Wereroo.
Can I just ask you a quick question on that? Because, and it may have been in the revised brief, but I just don't remember seeing it. I know the Commonwealth indicated that you failed to raise the presumption of sanity issue. They raised it. I don't see it in your brief.
Well, I think
That was an error. I mean, it was, but I don't see that you raised that the judge improperly instructed on the presumption of sanity.
well, I think that it's a matter of form over substance. I don't think he.
Okay, but just so I'm clear, it's not.
I don't think
it's not
that the
here.
brief comes out and says it specifically,
Okay.
but the brief does refer to the instruction at TR 255, which was the incorrect instruction. So the cases that talk about, well, even though the instruction was wrong, the evidence was really, really strong. This case, the evidence was not strong at all. And furthermore, I don't know how many times the judge instructed the jury that the burden is entirely the Commonwealth's. And I do concede that the judge did do that in this case, and the Commonwealth even did the same thing. But compared to the meager evidence of sanity, I'm not sure how effective the admonishments to the jury of the Commonwealth's burden of proof would have been.
Can I ask you on the evidence? I'm not understanding your final argument, which is that the jury failed to take into account substantial evidence of the defendant's mental impairment. How is that anything but speculative?
No, well, it's not, because there's a lot of case law that talks about.
Simply because they returned a verdict? I just don't. You don't cite any case law in that section of your brief that I can. Well, no, you don't.
The brief doesn't. I know. I took over the brief.
Okay, so the brief doesn't cite any case law whatsoever and simply says that, I suppose because they returned a verdict of guilty, the jury must not have considered.
Yes, he does make the argument. He doesn't maybe present any law, but the case law is very clear that there are factors that can be considered in the Commonwealth's proof of a defendant's sanity.
I guess my question is, why is our conclusion not that the jury considered it and rejected it, as opposed that they just didn't even consider it?
Well, because that's my third point, that this is also, if we assert that the evidence was insufficient, if the Commonwealth's proof of the defendant's sanity was insufficient, this court would do a de novo review of it. And according to the factors that different case law sets out, none of those factors are present in this case. The other cases have a defendant committing a murder, and then factors exist to show that the defendant was acting in a way to either avoid his arrest, as in Lawson.
What about what the defendant here said in the hospital the next day, that if he caused a scene, he could go anywhere he wants?
Yeah, and another thing that the defendant said in the hospital, which the Commonwealth used as evidence of his sanity, I think is quite the contrary, because who in Amesbury, Massachusetts, at the end of December is going to say, well, I'll be out, for Christmas Eve tomorrow, and then I'm going to play baseball. So I think that that's indicative of...
But let's focus on the first thing I asked, if we could. What about the statement that by causing a scene, I can go anywhere I want? Doesn't that suggest an ability to understand the consequences of one's actions and how to get something that one wants?
But that wasn't until he was at the hospital, and that was after the fact. And I think it's important to remember that at the time of the...
I think Lawson says, doesn't it, that may prove criminal responsibility through admissible evidence of the defendant's words and conduct before, during, and after the offense, including evidence of malingering.
But in Lawson, during the struggle, the defendant was saying, I'm not going back, I'm not going back. And he did tell, I think he did tell...
But Lawson says, that might have
Yes.
been during, but Lawson says before,
Yes.
during, and after. So you're not saying that the evidence of his conduct the next day was inadmissible, are you?
No, that
Just
would
it's a
have been
question of how the
admissible.
jury might weigh it. And you're certainly free to argue, oh, that was the next day. The jury
No.
shouldn't have given it so much weight, but we can't second-guess the weight the jury gave.
No,
can we?
I'll accept that, but I think that that is another factor. If you really are trying to get away with things, to get where you want, and you're sane, are you really going to admit it in that kind of a scope? And remember, there was no crime here. It wasn't like there was a murder, there was a victim that got whacked with a piece of lumber, like in the Wararoo case. There was no police that got kicked in the head in the Lawson case. The defendant wasn't trying to cover anything up. He had originally called for help, and then the police came, and then he decided that he didn't want help. So there was no underlying crime.
So just from what you're argued right there, doesn't that suggest, if not state overtly, that the defendant is making conscious decisions? He called the police because he wanted help. He decided he didn't want help, and this is how it manifested itself. And then it clearly escalated or deteriorated rapidly, right?
But I think that the court is entitled to consider the extraordinary ways that this case unraveled. That it's clearly not indicative of a person who is completely sane.
What about the Commonwealth's argument that his behavior is different depending on the person to whom he's speaking? So if he's speaking to a police officer and he wants the police officer off his property, he says, get off or I'm going to shoot you and I'm loaded to do so, words to that effect. And then when he's talking to his cousin, he says, sadly, calmly, pick your descriptive, you know what, just give me some cigarettes. If I get someone I trust, I'll walk out of here right now. How is that not powerful evidence that while certainly suffering some from or manifesting mental illness, he's has the ability and the capacity to understand the wrongfulness of his conduct and or to comport his behavior to the requirements of the law?
I'm not sure that it does indicate that he has an understanding of the wrongfulness of his conduct. If he's crying and says, if I can have some cigarettes, I'll go. He's not trying to cover up his crime. He's not trying to make excuses for his crime. Does he have a motivation in saying those things with respect to his own self-protection as the factors usually recognize? I mean, there's no element of his making statements that are specifically planned to exonerate him, which is the hallmark, which is the factors that is the hallmark of a malingering defendant. And in this case, we do not have a malingering defendant. And we do not have a malingering defendant. I want to just quickly review my notes in case I missed anything. No, I think I have everything. And if the court doesn't have any other questions for me, I would be glad to rest on the brief and the arguments. Thank you.
All right. Thank you for your argument. We'll hear from the Commonwealth. Ms. Johnson.
Thank you. Good morning, Your Honors. Kayla Johnson for the Commonwealth. May it please the court. I'll begin with the defendant's argument that he was entitled to the instruction on mental impairment short of insanity. And I think it's clear here that threatening to commit a crime is not a specific intent crime, and the defendant here was not entitled to this instruction. Threatening to commit a crime simply requires that the defendant express an intent, express an intention to inflict a crime upon another person in circumstances that would justify apprehension on the part of the recipient of the threat, that the defendant had the intention and ability to carry out that threat. And in response to Justice Singh's question in regards to whether there was an issue of whether this threat was communicated to the officers, this was not at issue at trial. And I think both parties agreed that that was not at issue at trial.
Sure, they were there to hear it, but does that go to whether this is a specific intent crime?
I don't think it does, because that the threat be conveyed to a particular person, I don't think necessarily means that this was a specific intent crime, not that the defendant had a specific intent while he was making this threat. The crime of threatening to commit a crime only requires that the person express an intention to commit the crime. And I don't think that that qualifies as a specific intent crime.
Does the defendant have a stronger argument if the defendant was entitled to this diminished capacity instruction than if it was just gratuitously injected into the case? In other words, do the defendant's arguments turn on whether threatening to commit an assault and battery is a specific intent crime versus a general intent crime?
Do you mean if he was entitled to this instruction and if it hadn't been given?
No. I mean, we have what was given here, and the question is, do we view that as something that he wasn't entitled to, and so how did it hurt him and maybe it benefited him, or do we view it as he was entitled to it, and if there are any flaws in it, then we need to at least review for substantial risk?
Well, Your Honor, I think it would be the first scenario you outlined there. I think he was not entitled to this instruction, and I think what he was given actually did benefit him. I think it gave the jury another avenue to consider when they were determining how they were going to decide this case.
Let me ask it this way. Do we need to decide whether this is a specific intent crime in order to resolve the defendant's arguments? I mean, I see three arguments here. One is that the jury could have become confused about whether this was two defenses or part of one defense. I don't see how that necessarily turns on whether the defendant was entitled to two instructions versus one. The second argument is that the jury lost track or could have lost track of the requirement that the Commonwealth prove criminal responsibility beyond a reasonable doubt. I'm not sure that turns on whether there was an entitlement to a diminished capacity instruction. And then the third is sufficiency of the evidence that he was criminally responsible. So I may not have summarized those accurately, but I'm asking you, do we need to decide whether this was a specific intent crime, such that he was entitled to what I'm calling shorthand, the diminished capacity instruction?
I don't think you do, Your Honor, because I think even if we were to assume that he was entitled to this instruction, I think that even with the portion that was given in error, the presumption of sanity, I think even if we presume the defendant was entitled to this instruction and that the instruction given was in error, I think that the record shows that even with this error, that the defendant was not prejudiced by this instruction being given, even with that presumption of sanity included. And I think that's because the judge in giving this instruction explicitly couched this instruction in permissive language, saying that the jury may consider this inference, but nonetheless, the court went on to explain that the jury should carefully weigh any evidence either way of sanity. And the judge also repeatedly and thoroughly instructed the jury that the Commonwealth had the burden to prove that the defendant was criminally responsible for committing this crime.
Can I ask you, I presume, but correct me if I'm wrong, that you're conceding that the defendant properly raised criminal responsibility, that there was sufficient evidence in the defendant's case to raise that issue?
Yes, because I think even at trial, the Commonwealth noted that there was evidence of mental impairment, and the Commonwealth noted that prior to trial, the Commonwealth had been provided notice that the defendant was going to seek a criminal responsibility defense at trial. He ultimately ended up withdrawing that and pursuing mental impairment short of insanity at trial, but I think the Commonwealth did acknowledge at trial that the Commonwealth is on notice for a criminal responsibility defense as well. So yes, the Commonwealth would concede that the issue of criminal responsibility was raised at trial. And then as to the sufficiency of the evidence as to criminal responsibility, I think it's really important to note that the defendant's words themselves highlight that he was acting on a rational motive at the time of the offense. He specifically said that by causing a scene, he could get what he wanted, and he noted once he was notified that he was going to be transferred, that his behavior immediately changed and he was more happy. And I think it's also very important to note, as Justice Brennan noted, that the defendant was able to differentiate who he was talking to during these 8 hours that he was in his house. And I think it's very clear that when he was on the phone with the police officers or any of the law enforcement that were trying to speak to him, he was using profanities and he was being very uncooperative. But when he was speaking to his cousin, she testified that he was calm, that he was explaining he just wanted some cigarettes, and that he would come out. And I think that really highlights that he was actually acting on a rational motive during this time.
Did I miss it? He was transferred to Bridgewater, right?
I'm not sure where he was transferred
On an
to.
18A maybe? I'm not sure. I didn't know what the vehicle was. But do we read anything into the fact that he was happy to be going to Bridgewater and saying he's going to play baseball? I mean, you'd be the first probably who was happy to be going to Bridgewater, perhaps.
I think it just highlights that he knew what he was doing. I mean, perhaps the context of it, and again, I'm not sure where he was transferred from the hospital, but I think looking at those words in the context of what was happening, he knew what he was doing when he was causing a scene and being difficult. And I think that highlights that he was acting on a rational motive at the time of his arrest, and that these words the next day make that even more clear. And I think it's also important to note that he was in his house for over 8 hours. I think it's a reasonable inference that the defendant knew his behavior had landed him in trouble. I mean, it was very plain that there was a high presence of law enforcement outside
If he'd
of
come
his
out
home.
right away, wouldn't you be arguing that that was a rational decision?
Perhaps, but I think here the fact that he didn't highlights that he was trying to avoid the consequences of coming out because he knew that his actions had landed him in trouble with law enforcement. And I think that the passage of time does make it clear that he knew what he was doing had landed him in trouble.
If he'd stayed inside for a week, would that indicate that he was acting rationally because he was afraid of the consequences of threatening? Or would that indicate that he had lost all ability to judge what was rational? Because he's in a house surrounded by armed officers and a state police crisis negotiating team and who knows what else. And it's not rational to think that this is going to end in, two ways, really.
I think that would be a different question than what we're faced with here. I think there would be a certain point where perhaps another inference would be possible if more time had gone by or perhaps less time had gone by. Maybe it would support a different inference, but I think the facts and circumstances here.
So there's a sweet spot.
maybe that's. I'm not sure what exactly that's that sweet spot might be. But I do think that that perhaps a different time frame would lend itself to a different inference. But I think the facts that we have here do support an inference that the defendant acted in a way that he was able to appreciate the wrongfulness of his conduct, and he was able to conform his conduct to the law. And then as to the sufficiency under the mental impairment theory, again, I think, as Justice Brennan pointed out, any argument that the jury may not have considered evidence of mental impairment, I think that totally goes to the weight and credibility of the evidence, which is in the jury's purview. And I think that that's not an issue that would be decided here. I think that was entirely for the jury to decide. And I think just the fact that the jury returned a guilty verdict, it does not lend itself to an inference that they did not consider this evidence. There are no further questions.
Seeing none, we thank you both
All
for your
sides
arguments.
agree. Thank you, Your Honors.
And we'll take a 15-minute break. We'll be back for the next three.
session. Please be seated.
All right, our next case is number 22P172, Tyrone Walker versus Julianne Pierre. And I think we're here from Mr. Greer.
Thank you, Your Honor. May it please the Court, Colin Greer for Julianne Pierre. This case is an appeal from a summary process eviction in the Eastern Housing Court. It raises two significant issues of law, the first being the notice required to be provided to a tenant in a summary process eviction proceeding. And that notice issue contains two sub-issues, the first being whether or not the tenant actually has to receive the notice, and the second being the proper notice to be provided to a tenant at will in those proceedings. The second issue in the case is respect to the housing court's equitable jurisdiction.
Right.
I see Your Honor had a question.
Yes, I mean, we ordinarily don't look at materials that weren't before the lower court, such as the materials regarding the deed and the homestead recording and so forth. But I did want to ask at the outset, is this case moot? The defendant still living in the premises?
Yes, Your Honor, she is still living in the residence, yes.
Okay, thank you.
So,
All right.
so she is still living in the residence, and if I may, I'll just jump back into the notice issue unless the court has other questions on
Yes,
that
that's
material. With respect to notice, the court made two significant errors, as I mentioned. The first being it relied on service of notice rather than actual receipt of notice, which is properly required, and the second being the time period for the notice. Speaking to the actual receipt issue, first, we have Ms. Pierre's testimony at trial and the court's finding that she testifies that she does not actually receive the notice. And I would point out that we are not contesting either the constable's testimony or the return of the constable with respect to that actual receipt of the notice. The constable testifies, and the court found him credible, and the constable's return indicates that he left the notice at Ms. Pierre's last and usual abode, the apartment, and that he mailed the mail first class with no return receipt required. Ms. Pierre testifies, and the court finds that she did not receive either of those two notices, and yet the court erred when it concluded that that alone was proper because it uses the term service rather than actual receipt.
Is there any rule for the presumption of the regular operation of the mails in this case?
There could be, Your Honor. I think you could provide a presumption for the regular receipt of mail. However, where she testifies that she does not receive the mail, that would then rebut the presumption and shift the burden back to the defendant in this case to show that she did, in fact, receive it. And so,
To the plaintiff, you mean?
sorry, yes, to the plaintiff, to the person.
Okay, but once the presumption is rebutted, does the judge need additional evidence in order to find that the notice to quit was received? Or
she would
what kind of
normally-
presumption is it?
Yes, Your Honor, she would ordinarily because simply a lack of credibility would not be enough to overcome the testimony of the defendant in this case that she did not receive the mail. And I will point out, Your Honor.
Well, if the judge discredits, I mean, the testimony, I didn't receive it, is in. Does the judge then need additional evidence? Does the presumption completely disappear? If I'm remembering my evidence class right, is this a bursting bubble presumption? And so additional evidence of her receipt is needed?
Yes, Your Honor, I would argue that it is required, that some additional evidence of receipt is required, where she testifies credibly that she does not receive the mail. And I would point out to Your Honor.
But who says it's credible?
Well, the judge, Your Honor. If you look at page 54 of the record, where the judge releases her findings, she credits the constable's testimony as well as the testimony of both parties and never gives any indication
Well, I thought she credited the constable's testimony on regarding what she called service, and then she credited the testimony of both parties. I'm just looking for exactly what she said, but it seemed that she credits the party's testimony with respect to the remaining issues, but she credits the constable on the issue of the notice to quit.
Well, Your Honor, yes, that's a fair characterization of the testimony. I suppose I would suggest that the constable never testifies to Ms. Pierre's actual receipt and in fact testifies specifically to the fact that no one was home when he went to deliver the notice in the first instance. And then Ms. Pierre's testimony regarding the signature requirement for the delivery of the mail and the lack thereof, that signature, should be enough to overcome the initial presumption that she did not receive the mail. And then the follow-up piece would just be how would the plaintiff show that she did indeed receive the mail, and that burden is on him to do.
How do you respond to the argument that your client was not entitled to notice?
Well, I would say, Your Honor, if she is in fact a tenant, first of all, she would be entitled to notice. And second of all, even if she is found
They're arguing she wasn't.
Even if she's found to not be a tenant, Your Honor, some form of notice would have been required, whether that is the length of time that we're requesting, the 3 months for a tenant at will where no periodic rent is paid.
If she's citing cases saying that if you're a tenant in sufferance, you don't get a notice to quit. Obviously, you need to have the summons and complaint.
Well, Your Honor, to be a
She
tenant...
did because she showed up in court.
Yes, but to be a tenant at sufferance, she would have had to have been some tenant and had that tenancy terminated prior to becoming a tenant at sufferance. And if she were a gratuitous tenant, I think the jury is out on whether or not she would be required to any notice terminating that tenancy.
What's the difference between a gratuitous tenancy and a tenancy at sufferance, if you can explain?
I think a tenant at sufferance would occur after some other, the cases I cite in the brief, and I can't think of the citation off the top of my head, but the cases we cite in the brief for this with respect to a tenancy at sufferance is that the tenancy at sufferance requires a person to remain in possession of a premises wrongfully after the termination of some other status. So she would have had to have some other status prior to becoming a tenant at sufferance. Otherwise, she would be, some other form of trespasser in that sense. And considering she lived in the apartment for 2 years with the permission of the plaintiff in this case, that finding would sort of be against the weight of the evidence here.
And what's a gratuitous tenancy?
So a gratuitous tenancy, as described in Lavelle and sort of the other cases that are in both parties' briefs, I think we agree about this, really it's the lack of a tenancy at will that establishes a gratuitous tenancy. So you have no exclusive possession of the property and no consideration in exchange for remaining there. And here, first of all, Ms. Pierre is in exclusive possession of the premises. There's really no dispute about that fact. And second of all, you have the payment not only of the utilities, but also of the improvements to the property that she testifies to after she moves into the property and continuing after Mr. Walker moves out when she obtains exclusive possession. And all of that is sufficient consideration, so we agree that that is not a periodic rent payment, but that rent payment is not required to establish a tenancy, just any sort of consideration, any value flowing in the direction of the plaintiff.
So the landlord's argument that there was no notice to quit required her because it was a tenancy at sufferance is, it seems to me, an alternative ground for that the landlord's offering for affirming. It wasn't raised below. That doesn't mean it can't be raised now, but does that involve findings of fact, whether there was a tenancy at sufferance here versus a tenancy at will? Because the judge, which the judge didn't make. The judge didn't say there was an agreement for Ms. Pierre to pay the water or to pay for improvements, and that was consideration for letting her stay.
I agree that the judge doesn't make findings with respect to the agreement itself, Your Honor. I think there's other evidence that suggests that such an agreement existed, but I don't think the judge's findings are clear. What the judge does find is the consideration flow. So she does find that Ms. Pierre was paying for the utilities at that time, or finds, rather, that Ms. Pierre testified to paying for those utilities, and then that she credited Ms. Pierre's testimony with respect to that issue, and therefore, that factual finding we feel is solidly in the record. And so the question outstanding is...
But consideration without an agreement is...
We agree to that, Your Honor. That's true. So with respect to the agreement, first of all, the fact that she lived in the apartment for 2 years tends to suggest that there was an agreement between the parties for her to do so and to continue to do the things that she was doing prior to the parties' romantic separation. So pay for the improvements to the property, pay for the utilities bill, including the water bill for the entire building. And then furthermore, the fact that the plaintiff both serves a notice to quit noting that there's a tenancy, so the notice to quit says termination of the tenancy, and a summons of complaint saying the same, tends to suggest that the plaintiff both subjectively and objectively also understood that there was an agreement between the parties creating a tenancy here.
So if the judge didn't make a finding about whether there was a tenancy at sufferance or tenancy at will here, understandably because the issue wasn't put to her, and we think there's some question about whether there was a tenancy, what the nature of the tenancy was. Would the appropriate relief be to remand for the judge to make additional findings, remand for additional evidence, or order dismissal and the plaintiff can start over again if he wants.
I think a remand for additional findings would be appropriate in that case, Your Honor. So asking the judge to clearly conclude what the relationship was between the parties, because I agree that the language in the opinion doesn't specifically say, so it speaks to service. And I think this would also clear up the issue with respect to, if I can shift gears a little bit, to the timing of the notice to quit. So, because that issue is also semi-factual in that we agree that Ms. Pierre is not paying rent, and whether or not she's a tenant at will would also speak to what notice period would be required to terminate the tenancy. So whether that would be the 3 months notice, or, as there's no dispute here, the 30-day notice that was provided in this case, which, absent rent payments, would be improper in either case. So with that in mind, Your Honor, actually, I would say if you find that the notice period, if the length of the notice would be improper with respect to a tenancy at will, you could act on that issue as well.
But then we've still got the alternative argument that no notice to quit was required.
That's right, Your Honor.
On the equitable defense, what should the judge have done here? Looking at the record, the judge was, it appeared to me, giving the tenant kind of the benefit of the doubt. Like, you've got some claim here. I don't know what it is. She's not clearly articulating a constructive trust here or a resulting trust. I don't know. Is she talking about a partition? I'm not sure.
Well,
you know, if the judge hadn't thought to send it to the probate court or give her an opportunity to go to the probate court, I shouldn't say send it, what should the judge have done?
The judge in this case was required to address that equitable defense. So the defense goes to the ownership of the property, which is within the prima facie case.
So play that out. What would the judge have said, okay, you seem to be making an argument here that I should order him to refinance and pay you half the proceeds. What's your legal basis for that?
Well, Your Honor, the statute, first of all, grants the housing court concurrent jurisdiction with the probate and family
Maybe
court.
it does, but I'm asking, practically speaking, with the judge faced with a pretty inchoate expression of a claim here, one that, you know, was never in an answer.
Even if, yes, Your Honor, even if the housing court may not have wanted to address the partition issue specifically, if Ms. Pierre is entitled to partition as she's raising at the trial, or if she's entitled to a constructive trust, or however we want to interpret that, which I would argue as a pro se litigant, you know, the court has a responsibility to interpret her pleadings liberally. With that in mind,
right. Well, there's no pleading here, and there is understanding that she's self-represented, not a very clearly expressed theory. You're saying that the judge had to exercise the housing court's jurisdiction, but how would the judge have gone about that here?
Well, here, Your Honor, she's arguing that she's contributed to the purchase of the property and to the upkeep of the property since the purchase, which is an argument for equitable ownership of the property, not, the deed notwithstanding. And so here, the housing court's only responsibility is to address the ownership issue, which is a prima facie element of the plaintiff's case for possession. And so if Ms.
So if the judge had said, and I find that the plaintiff is the owner, because the defendant hasn't put on any evidence otherwise, or sufficient evidence otherwise, would that have been sufficient to address those equitable defenses?
I think, yes, Your Honor, it may have been a little bit too quick action on behalf of the housing court here, where, Ms. Pierre did indeed raise something. I think there was clearly an argument that she thinks that she's entitled to some ownership of the property, and I think that the housing court recognizes that when it stays the case to send it to the probate and family court, and by that action alone, it at least suggests that, as the court says, Ms. Pierre, quote, raised an issue with respect to the division of value of the premises, which is enough to say that the court recognizes that Ms. Pierre may have some ownership claim over the property, and it's within the purview of the housing court to decide that issue, and not only the purview, but it's actually mandatory.
But the judge then has to go figure out what are the elements of a constructive trust, what are the elements of a resulting trust, what are the elements of a partition, what are all the theories that she could be articulating here, and how do I deal with all of those?
Well,
I'm just asking as a practical matter, is it realistic to expect housing court judges to do that?
She may not have to go that far, Your Honor. The real question is just, did Ms. Pierre put up enough to say, I am a part owner of this property, and if so, or at least enough to rebut Mr. Walker's superior claim to title, as was his burden at trial. And so once she puts on that rebuttal evidence, again, Mr. Walker's burden is to say, no, she didn't do these things. She did not contribute to the value of the property. She did not pay for it. And there was no, improper transfer, and I'm the owner of the property. And that, that's enough to ask of any housing court plaintiff, is to prove that they are indeed the owner of the property for which they're seeking eviction.
But you don't really ask him to to come forward with more specific proof of that unless the defendant has raised some kind of specific argument otherwise, and to say, I feel that what you should do, Your Honor, is order him to refinance and pay me half, doesn't seem to me that clearly to say, I own half.
I think with her pro se status, Your Honor, it would have been enough to interpret that to suggest that she was at least refuting his claim to ownership, and that could have been enough for the housing court to act there, if there are no further questions.
Seeing none, thank you for your argument. We'll hear from Ms. Greenman.
Good morning, Jordana Greenman for Tyrone Walker. May it please the court. I wanted to point out just very quickly before I forget that both parties were pro se in this action, and I think that's important because as I've told my client numerous occasions, there would have been a lot of things I would have done differently had he come to me from the beginning, but he didn't. So to first get to the issue of service, in addition to stating that you will be opening the floodgates by determining that a constable's return of service is no longer sufficient in a summary process action, I raise just for the purpose
Well,
of...
why would it not be sufficient?
I do believe that it is sufficient.
No, why, I mean, it's not sufficient to show actual receipt. Would you agree with that? It might raise a presumption, but the constable's return doesn't say she received it. It says, I left it at her,
Yes, that's
I put it under her door, and I put it in the mail, regular mail.
Which has been the manner in which
Right.
most, I believe, civil litigation is served. There's divorce cases which you have to actually get the person in hand, but when you knock on somebody's door, they're not home, you put it under the door as you always have, you send it in the mail.
So what about the Ajardi case that seems to require actual receipt? Is that not a correct interpretation of that case?
I don't think so, and I also think that's where and why I raised the issues of the other property, which were not raised in the lower court, because I think it calls into question credibility in a very, very serious way.
Well, but that wasn't before the judge, so really...
The fact that the occupant defendant said that she did not receive the mail, she also said that she did not have the ability to buy property when she had bought property 6 months prior to that.
So, Ajardi uses the phrase actual receipt. So how are we supposed to interpret those words from the Supreme Judicial Court, quoting an appellate division case, other than what they mean?
Well, I think that the presumption of receipt based on the regular mail and the fact that it did not get returned to the constable unless there has been new rules that have come out about service. Again, if you opened up probably 90% of housing court files, they have not been served in hand. So again, opening up these floodgates of every single person who's ever been a defendant in a summary process case who generally testify that they never received notice. It is very common. Constables have had to be at more hearings than not since the reopening of the courts since COVID.
Okay, so if we assume there's a presumption of regular operation of the mails, which is that something that was mailed was received, and then the tenant comes in and says, I didn't receive it, can the judge, although the presumption may have been rebutted, can the judge still go ahead and find that the notice was received, or does the judge need additional evidence from the plaintiff landlord in order to find that it was received?
I think that the judge at that point needs to make a credibility examination and determine what the judge feels, who the judge feels is actually telling the truth, which is why the constables have been coming into court to testify.
I mean, they could both be true. The Commonwealth could be, and the judge credited the constable here. Sorry, I didn't mean to say Commonwealth. Judge credited the constable saying, I believe that he slid it under the door. I believe that he mailed it first class. What she didn't say is, I believe she received it.
Exactly, because he can't. He can't say something.
Well, of course, he can't say that, but does the judge need to find it, given this language in Ajardi?
I don't think so.
And I guess I'll ask one more time, how can we disregard the language in Ajardi?
That's a good question. I think that what Ajardi does not suggests is exactly what's supposed to happen. What is that proof that you're saying goes further to say, are people supposed to start recording their front door everywhere so that you can prove, but how do you prove actual receipt? If a constable tapes something to a door, but you can't prove that no neighbor came by and ripped it off the door, at what point will it be enough? So I think that what the constable has done is enough.
Right, but that still doesn't,
And in a
it
Jordan,
doesn't,
I
excuse me one
believe
second.
that
Excuse me, what, can I just finish my question, please? Thanks. That doesn't really answer the question, which is, what is the standard? If the standard is actual receipt, that's one thing. And it doesn't seem like you want to get on board with that, as opposed to what are the ways through which a party can prove that, and what is the judge's responsibility for making that assessment, right? Aren't they two different things?
Yes.
Okay, so then, do I take it then you're willing to concede that what a judge says, which is a tenant is entitled to actual receipt of the notice to quit, means they're actually entitled to actual receipt?
Yes, and I do
Okay.
think that in this instance, what the constable testified to and the surrounding circumstances do show actual receipt.
But the judge didn't find actual receipt.
No,
Perhaps
the-
the judge could have, I don't know, but
Yes.
you would agree that she didn't find actual
I
receipt.
would agree that there was yes, she did not make a specific finding, and I do know that having trials by Zoom was difficult for everybody. But moving on from that, the most important point when considering that we do not look at stuff that was not testified to and not in the record is entirely devoid of any testimony that this person is a tenant. At no point during the trial.
Well, she lived there. You're arguing she was a tenant at sufferance,
I'm arguing that she was
which
either
is still a kind of tenancy, isn't it? So just to be clear about our terminology, you're not arguing she wasn't a tenant. You're saying she was a tenant at sufferance at most.
I'm saying, in my view, she was a guest, but in legal terms, she was either a gratuitous tenant or a tenant at sufferance. And what ended to put her in the position of being a tenant at sufferance is the fact that there was a romantic relationship. My client bought a house with his money. He lived there with his family. Then the romantic relationship ended.
Do you agree that in the cases about tenants at sufferance, there was some prior status, such as a tenant at will, that ended in order to give rise to that tenancy at sufferance?
Not necessarily a tenancy at will.
Can you, not necessarily a tenancy at will, but can you point to any tenancy at sufferance case where that tenancy didn't result from the termination of some prior form of tenancy or even ownership in the post-foreclosure?
Yeah, the foreclosure cases.
Okay, so this wasn't a foreclosure case. You're arguing that she was not a tenant at will or a tenant under, for a set term.
Yes.
What form of tenancy terminated here in order to give rise to the tenancy at sufferance that you say exists?
She's similar to the defendant in Lavelle, from the way that I see it. She was a gratuitous tenant. She was authorized to live there because she was in a relationship with the person who owned the property. And that ended with a restraining order brought by her, and he therefore had to leave. Whatever she did thereafter, whatever bills she put in her name, he had no part in that. She testified.
So at what point did the tenancy end? And what kind of tenancy was it while they were still in the romantic
I don't think that there
relationship?
was any tenancy. I think it was.
Ever?
No.
So
think-
even when they were living there together?
No, I think she was a family member living with the owner.
Okay. And then she became not a tenant at sufferance, but a gratuitous tenant?
Either a tenant at sufferance, since there has to be a term for what she is, she's either a gratuitous tenant or she's a tenant at sufferance.
Do you agree with Mr. Greer that that's something that the housing court judge needs to address, or do you think it's evident in the record?
No, I think that it's evident in the record, and I also think
Where?
that she did not speak by her lack of testimony of having any tenancy, period. She testified, we bought the house. She testified that she was the landlord while he was incarcerated.
Okay. So would you agree that tenancy by the entireties or a joint tenancy is a form of tenancy?
Yes and no. I don't think of them the same way. I think of tenancy by the entirety and joint tenancy and tenancy in common as being terms I use when I'm working in my conveyancing practice. I don't think of them in the housing court context. So, yes, I think that if a tenant by the entirety or a joint tenant went into court to try to evict the other owner, that would not be possible. But a tenancy in the case law, and Lavelle talks about it, it requires a meeting of the minds, it requires some kind of agreement. That never happened in this case.
Yeah, we don't know whether it did, it seems to me, because this wasn't raised, and the judge didn't have occasion to make findings about it. I'm not saying that you can't raise it as an alternative ground for affirmance, but wouldn't affirming on that ground require us to find facts based on evidence that isn't all that clear?
He testified there was no meeting of the minds.
Well, he said there was no agreement for rent. He didn't say there was.
He actually testified there's no agreement. I don't have any agreement between me and you that you're renting the first floor apartment out.
Right. No agreement for rent. But he does not say, I don't have, number one, the judge wasn't required to credit that. Number two, he didn't say there's no agreement whatsoever for her to be there. He just said there's no agreement for her to rent it out. And she's saying, I acknowledge I didn't pay rent, but I paid utilities. At some point, maybe I paid for improvements. I guess what I'm leading up to with this question is where the judge was not asked to and did not find whether this was a tenancy at will or a tenancy at sufferance, can we affirm on that alternative ground, or do we need to remand it for further findings, or is this just a case where the plaintiff didn't satisfy his burden of showing a proper receipt of a notice to quit, and so judgment should have entered for the defendant, and he can start over if he wants?
As in the Lavelle case, where the court found that the occupant was not a tenant, was not paying anything, there was no evidence of any payments. There was also no evidence of any payments in this case. There was testimony that I think the fact that came up about what was not truthful testimony during the defendant's testimony should come into that. And as well as the fact that it has been 3 years. And the benefit of that and the harm to the plaintiff in the amount of time that has passed. And the plaintiff's inability to really do anything at all with his own property for 3 years now. Despite the fact that he testified that he does not have any agreement for her to live there. And while I understand that pro se litigants are held to the same standard, I do agree with Mr. Greer that both of these parties were pro se. What they said, probably both parties, wasn't what they would have said had either of them been represented at the time. So I think that the judge's handling of the trial was sufficient. He testified.
Let me just go back to the question I was asking about what the proper approach to this tenancy at sufferance argument you're making is. If we agree that that's an important issue in the case, because if she was a tenant at sufferance, then she's not entitled to a notice to quit, then do we remand for further findings on that issue, or do we instead say it was the plaintiff's burden to show proper receipt of a notice to quit? He didn't do that here because he didn't prove that she was a tenant at sufferance, and therefore the case should have been dismissed. If he wants to start over again, he's free to do that with serving a new notice to quit. So is it remand, or is it order dismissal and he's free to start over again?
Well, then it's remand in that case.
And why is that better? Why shouldn't we just say he didn't satisfy his burden of proving proper receipt of notice to quit, or prove that none was required, so therefore he loses and he's got to start again?
Well, that's a good question. I do think that he met his burden. I do think that the circumstances surrounding the relationship, the end of the relationship, the desire for her to leave his home, and what she testified to specifically, if he wants me out, he just has to pay me, essentially, is what she said. She said he has to refinance. she didn't really claim ownership. She just claimed that she would leave if he refinanced and gave her half. Half of what, I don't know. But that's what she testified. So I don't think that there's a burden to require any acceptance, receipt of any notice, because the occupant did not testify that she was a tenant. She testified that she was an owner, and she did not meet her burden of proving that, nor did she try. And I do understand that Judge Chaplin ordered her to go to the probate court and file some sort of action in equity. She did not file anything. She had an obligation to file documents 5 days before a trial on Zoom. That is what the trial notice requires, that you file your exhibits 5 days in advance. She filed nothing, not even an answer. And she had the benefit, unlike him, of the Volunteer Lawyers Project, of GBLS, of Harvard Legal Aid, of all these different services that assist tenants that he did not have the benefit of.
All right. Seeing no further questions, thank you for your argument. Very interesting case. We'll take it under advisement. Our next case is 22P416, the First Church of Christ Scientist versus ERA Charter. Mr. Revere.
We're still counting down. Thank you, Your Honor. Paul Revere for the appellant slash defendant, Ara, also known as Barbara Charder. This matter involves essentially two issues. The propriety of the issuance of a default for failure to comply with a pretrial discovery order, and then once the default was issued, the propriety of whether judgment should have been issued in favor of the plaintiff slash appellee First Church of Christ Scientist. With respect to the first issue, we had a little disagreement of law as to whether the judge is supposed to make a finding of willfulness, bad faith, or fault on behalf of the defendant to issue a default for a pretrial order. It's kind of interesting when I looked at this. The Keene case, which is always cited for the proposition, doesn't really say that, but later cases such as Short v. Marinas U.S. Specifically hold that the showing requires willfulness, bad faith, or fault to issue the default. In this matter, the court ordered an inspection of a property. The specific court order allowed inspection by the plaintiff's, quote, expert. And that's very important because the date of October, I believe it was 15th, 2021, was chosen because, and it's cited in the record, the expert from Wisjani, an architect, spends his winters in Michigan and was leaving on October 18th, the following day, or a couple days following the weekend. October 15th was a Friday. That's very clear from the record between the parties in that matter. Ms. Charder did allow, when meeting at the property with Mr. Fumarola, the expert, a construction expert, and I think I'll call an assistant, but I think that's understating her qualifications. She was also an architect of Wisjani was there. She agreed to allow the architect to enter the property, but no one else. So
Not even counsel? Not even counsel?
Specifically, yes. I was not present there. I think that if that isn't clear from the record, I was not there. I expected her to let them in. But she agreed that the so-called expert for which this date was set in October could enter the house at around the appointed time. There was an 11 o'clock time. It was actually, according to Mr. Fumarola's affidavit, it was around 11:40-ish when she made this. A protective order was filed, or excuse me, a motion for a protective order was served with the court on that morning by email, it was then denied later in the day. So I think if you start from the first instance here, was, as they say in contempt, was there a failure to comply with a clear and direct order? No, there wasn't. She complied with a clear and direct order. What she didn't do was she didn't let all of the entourage in at the
But
time.
after that was cleared up by the judge's emergency order, I think at 1:50 p.m., she still didn't let them in. And she didn't pay any heed to the judge's prior determination that she needn't be present.
She did not pay heed to the issue of that she need not be present, but this is a property on Nantucket. She, without waiving attorney-client privilege, said that she would let them in, did not ask me to attend at the time. She was there. She did offer to let them in later in the afternoon and meet them there. Ms. Charder is a fairly large, obese woman in her 70s, and
But if it wasn't practical, if someone needed to be there, and she was the only one who could be there, it was incumbent upon her to say that and show that to the judge before the judge said, you don't need to be there. I want to make it clear this has to go forward, and she's welcome to attend if she wants, but she does not need to be there.
Yeah.
So I don't understand how, once the matter of whether one or more experts could come in was cleared up early in the afternoon, there was any issue about what the judge expected and had ordered to happen, and she didn't let it happen.
Well, I think she learned of the issue sometime around the judge's order, sometime around 2:30, if you look at the record in the case. And then she didn't let them in. But the question becomes, there's no findings or anything as to specifically why the judge ruled that default should issue in this matter.
Is it your position then that findings are required as opposed to showings from which we can infer a judge made a conclusion or determination?
Okay, well, the point of the matter is we're dealing with an abuse of discretion. And if you don't have a specific reason or finding, it's impossible to review abuse of discretion because you don't know the reason the judge acted.
But
Whether
at some
it was,
point, it's apparent on the record.
Well, is it apparent? Is it her issue of not letting all of them in at 11:45, or is it her failure to get over to the property between 2:30-ish and 3:30 when my brother and the experts decided that they could no longer, and this is in his affidavit, decided they no longer could stay and meet the boat and return home on that same day? We don't know what the judge made the basis of their decision. They simply said, well, for the reasons cited by the motion, but not what specific one. And it's, how do you review abuse of discretion under those facts?
Couldn't it have been all of those things? Why would one thing have to be isolated?
It could be. The thing is, in my opinion, there isn't an answer there. There isn't a findings.
Why don't we just take that literally? For the reasons cited, what reasons were cited? Okay, those are the reasons. Seems like a fairly logical step-by-step analysis. What am I missing?
I think if you look at that, I think my client complied with the clear order to let the expert in, the expert who the date was set for.
Excuse me, I didn't mean to interrupt, but just in terms of my question about the judge's findings and whether they're sufficient, if a judge says, for the reasons cited in, and then identifies a document, and then we look at the document, and that document lists reasons, why is that not sufficient?
Well, I think the actual...
As opposed to for reasons 2 and 3, but not 6 and 12. I mean, obviously, hypothetically.
The actual court order...
Yep, looking at it.
...says, after review of all submissions, the motion is allowed for substantially the reasons. Substantially. It doesn't say for the reasons.
Good point.
Substantially, we have a little gray area in there. The second part of this case, too, is what is the impact of a default? The impact of a default is the allegations of the complaint are taken as true.
And you're saying even if taken as true, they don't make out the claim?
They do not make a claim for waste.
What's missing? What's missing?
What's missing is, if you look at the concept of waste, a person is only required to maintain the property in the condition that they receive it. And I cite a Rhode Island decision. It's interesting dealing with waste. You get some very old decisions, but from one Rhode Island reporter. It basically is, if you're left a dilapidated building, you don't have to improve it. You just have to maintain the building at the level it was beforehand.
What about the expert's conclusion that the condition of the property reflected a degree of neglect that permitted severe and substantial deterioration? You're saying it permitted it, but it doesn't say it actually occurred? Is that the distinction?
There was no evidence on the record as to what the condition of the building was when Mr. Pauley left it. In fact, there is some evidence that the main value in the property is the land. This is Nantucket. I say that in a word. The other thing, too, is even if it establishes the facts pled in the complaint, it is much like getting a default when you don't have a sum certain. The judge still needed to have a hearing as to what the appropriate relief was.
Well, but the judge here, there were two counts for waste. One was to vest title in the church, and the other one was for damages, count 2. The judge ended up dismissing the count for damages. So I don't understand how a finding about the dollar value of the deterioration was necessary to the relief the judge granted.
Well, I'm not saying necessarily the dollar value. What I'm saying is that it's not like a sum certain case. There's two parts of it is, well, okay, if these facts are established, what is the appropriate relief?
Well, you know, Rule 55 provides for a default, which basically says the defendant can't contest the facts, and then there's an issue of what relief. But Rule 37E2C provides for default judgment as a sanction. Why does a judge, when sanctioning a party under that rule, need to say, okay, it says default judgment, but I'm not going to enter a judgment. I'm just going to default you as to your ability to plead facts, and I'm going to have a hearing on sanction.
Well, I think the Producturus case addresses the issue straightforward. And in fact, there's a separate case that I actually hadn't cited, which is
How does the Producturus case say that there must be, that the judge cannot enter a default judgment and must hear under 37B2C?
Well, the judge has to make a decision as to whether the facts that are pled are entitled one to relief. Producturus dealt with the...
But Producturus was a default only as to liability. Here, the judge was working under 37B2C, which authorizes the judge to enter a default judgment.
It authorizes them to do it, but I think if you look at it, I think Producturus comes to the point, and the case that I was getting to is Nancy P. v. D'Amato, which is 401 Mass 516, and it points out on Producturus, because this is an easy one to understand, that even though a default happens, you can't issue a judgment for negligent infliction of emotional distress when the allegations of the complaint don't make a viable tort for that. So that's the answer to, is that you still, just because you're defaulted doesn't mean that you can automatically win the case. You still have to have an actual claim that is recognized by the court being pled.
So what element, then, this comes back to the Judge Singh's question, what element is missing from the complaint that was necessary to support the relief that was actually awarded here, which didn't award damages, it just vested title in the church and declared that she had forfeited her interests due to waste?
Judge Gilday ruled on a summary judgment motion, if you recall from the record.
Right, and said, I want more evidence regarding dollar value. I want evidence regarding the extent of the damages. How does that bind the judge not to enter a later judgment that doesn't involve damages? He dismissed the claim for damages.
When I look at it, Judge Gilday said he sanctioned my client, and I was not around for the first round of sanctioning. I was not her attorney at the time when she didn't answer discovery. He sanctioned my client in the summary judgment matter by saying, I'm taking everything pled by the plaintiff, First Church, as true, and I'm finding that I still can't issue judgment in the First Church's favor. So I think it's a law of the case issue. Judge Gilday looked exactly at these issues.
But it's not the same question that's presented. He was faced with a summary judgment motion on all 3 counts.
Well,
And he said, I'm not granting judgment. Then later, the judge grants judgment on 2 counts, one of which, neither of which involves damages, which was seems to be the claim as to which the judge previously said, I don't have enough undisputed facts.
I'm not sure he couldn't have issued, Judge Gilday, with the summary judgment matter, could have, but didn't, find that one of the counts was established and issued a judgment at that time. He found that he couldn't. I'm not sure how the judge's decision should be parsed into, well, because he couldn't issue it on counts 2 or 3, he couldn't have issued it on count 1 at that time. Thank you, Your Honor.
All right, thank you. We'll hear from Mr. Fumarola.
Good afternoon. May it please the Court, I'm Carl Fumarola on behalf of the First Church of Christ Scientist. The Superior Court judge clearly did not abuse his discretion in ordering sanctions of default against the defendant. The defendant engaged in numerous repeat violations of discovery rules and violations of several court orders. Her conduct was intentional. It was in bad faith. She received warnings. She received second chances. And she continued to obstruct, and she lied to the court about it. She got caught fabricating excuses just for the sake of being difficult, and she got caught perjuring
The judge
herself.
didn't say that. It might have been a permissible finding, but the judge never resolved that credibility question, at least explicitly.
It was a section in our papers, and I'll get to that. But then there's other evidence in the record where it's clear that she was making up excuses, and I'll get to that. But the court took all of those facts into consideration that's set forth in our papers, and it issued the sanctions. And it also considered that she had already been sanctioned beforehand, earlier, and she was expressly warned that a default would enter if she didn't cooperate with the inspection. And then after that, she failed to comply with 2 more orders, and a default was entered.
Excuse me, can you address Mr. Revere's argument that the judge's essentially a docket entry that the decision is made for substantially the reasons that were in your memorandum, that's ambiguous, and I'm paraphrasing, but that's basically, that's ambiguous, and what we do with that?
I agree with what the panel said earlier. It's pretty clear that our papers had painstaking detail, lots of facts and evidence, and the court adopted it.
Well, it says, if it says for the reasons, because I've seen that, we've all seen for the reasons cited in the brief, for the reasons in the memorandum of law, or the memorandum. Yep, but it said substantially. So what do we do with that substantially?
Well, it means for the reasons stated in our papers, or for almost all of the reasons. I don't know how you interpret substantially, but you don't need to have specific factual findings. This was dealt with in the Greenleaf case, where the appeals court said, for a Rule 37 motion, it's always nice to have specific factual findings, but they're not necessary.
And is that what is your response to the Keene case that says we generally require that the extreme sanction of default judgment be predicated on a finding of willfulness or bad faith?
In the official comments to the rule, it says that willfulness is not required. The rules were specifically amended previously to eliminate the requirement of willfulness. It says that in the comments to the rule, and it's in the case law that it's not specifically required. It says that in, I think it's Greenleaf, the Goss case says it. Now, in the Goss case, the court said that we wanted a finding of willfulness in this specific instance because it appeared from the record, or there was a claim that she was unable to comply because the person was ordered to sit for a deposition and they claimed to be stuck in Poland. And so that raised due process issues. Even if the person wanted to comply, they couldn't, so they had to go further in that unusual instance, and this, to require willfulness. There was no such instance in this case where the defendant was unable to comply. The record's clear she was just being difficult and disregarding the orders. And even if willfulness was required, it's very clear from the facts that she was being willful. And I'll get to that. It seems that the panel's very familiar with the facts of this case, but I was just going to touch upon some high points, and I'll get to that where she's caught, just being deceptive. But it starts with a long history of obstructing discovery. It took about a year for us to get an order compelling her discovery responses because her attorney withdrew because she wasn't cooperating partway through, and so then we had to go through the discovery process or the motion to compel process again. And then after a year, we were left with nothing. And this was after we granted numerous extensions with the understanding that, okay, we'll grant the extension, just give us the necessary discovery. And after all of that, it was just stringing us along. We get the order, and then she ignores it. And then the discovery period ended, and we had a summary judgment deadline approaching. So given that our facts were entirely uncontested up to that point in time, we moved for summary judgment and for sanctions barring her evidence or evidentiary inferences in our favor. And the court allowed the minimal sanctions of barring her from submitting any undisclosed evidence, but it denied our motion for summary judgment, ironically, because we lacked certain evidence that Ms. CHARDER obstructed us from obtaining. So then at the Rule 16 conference, the judge allowed us to conduct this critical issue of the interior inspection. And this was after opposing counsel agreed to do or suggested doing the inspection at the same day as the Rule 16 conference when everyone was going to be on the island. But Ms. CHARDER, again, she obstructed that, which necessitated another unnecessary trip back to the island. And the court was very clear. Ms. CHARDER was in the courtroom. The court could tell that she was being defiant. She didn't want to pick a date for the inspection. And the court warned her that it has to go forward on this date. And the court specifically said that whether or not she could attend, it still had to go forward, and the court warned her that a default could enter if she doesn't cooperate. So that day, the church's lawyer sent notice. We planned to do the inspection at 11 o'clock. That's a time that everyone agreed upon for scheduling the Rule 16 conference because that coincides with the ferry to get out there. And then the day before the inspection, Ms. CHARDER wanted to move it to very early in the morning or late in the afternoon. That was just impractical to do. Everything was booked. The experts were booked. Everyone had their ferry tickets. And so we rejected that, said that we're going to appear as scheduled. And so then we did. Everyone appeared at 11 o'clock, and right around that same time, Ms. CHARDER filed a motion for a protective order saying that she wanted to do it early in the morning, which was moot at that point, or late in the afternoon, and she wanted to bar everyone except one expert from appearing. And also the court had already eliminated the excuse of her not being available. And also, her claim that she was unavailable later proved to be false because she appeared at the property at about 11:30 anyway. So when she's telling the court in the motion and telling the church or in her own lawyer that she couldn't be there, that was just untrue. So just before noon, she refused entry to the group. That's when she was there. That shows she was faking the scheduling conflict. And then after that, about 1:50 p.m., that's when the court issued its order on the emergency motion to grant access to everybody, and it denied the motion in total, which also asked to delay it until after 4:30 p.m. And everyone was waiting nearby for the court's ruling, so we were at the property 10 minutes later. I spoke with Ms. CHARDER's attorney and requested immediate access because we had tickets to go home by the 5:50 p.m. ferry, because after that, I think the next one was 7:40, which just wasn't reasonable. And so we're at the property waiting for her, and then the church's attorney went down the road to where Ms. Charter's residence is. It's about a half a mile away. It's about a minute down the road to see what her property looked like, because there's a code enforcement action against that property, and we wanted insight as to what we could expect from the town for this property. And at about that same time, the church's council received a phone call from Ms. Charter's attorney saying that she can't provide access until after 4:30, despite the court denying that. She can't provide access till after 4:30 because she's busy providing bus tours. And the church's council at that very moment was looking at her sitting in her lawn, in a lawn chair in her front yard on her smartphone. So it was entirely false. She could have come down and obeyed the court's order. I mean, it was willful for her not to. Later, Ms. Charter argued that, well, she has mobility issues. She had trouble traveling the mile down the road or half a mile, which takes 1 minute, which is laughably ironic because her excuse before was that she's busy providing bus tours all around the island. So it's definitely a willful violation, even if it's required. And so after waiting around for about 2 hours, the church's group of experts departed the island, and we asked the court to follow through with its warnings to issue a default judgment, and the court agreed for substantially the same reasons that were all detailed in painstaking detail in our papers. And then there was a section in there about her also being deceptive to the court, and that was in her summary judgment affidavit, where I know it was hard to read in the appendix, but I quote from it in my affidavit. There's no objection, I'm quoting for it. I'm misquoting it. She claims that she lived in the property in recent years. She claimed that in that affidavit under oath submitted with the summary judgment papers. And that proved to be false. The town provided evidence showing that the water service had been off for many years. And now she's signed the affidavit to say that, apparently to indicate that the property hadn't been neglected and it was habitable. And the whole case was about the property being neglected and not habitable. So she was deceptive about saying that she lived there. And the court had that evidence. That was a prominent section towards the end of our papers. So that's more support for her willfulness and bad faith. On the issue of testing the sufficiency of the complaint, it's not required in Rule 37. The Fleming or Proctoria case talks about, that's an extreme example, as the court noticed there are some distinctions, but that was where a default was entered against a party on a claim that was never even asserted against the party. So that's the reasoning how it's different. But even if
Wasn't asserted or wasn't properly asserted?
it wasn't asserted against the party, I'm not entirely sure, but I remember no, I don't even think it was even attempted to be named against the party. I believe it had to do with, I'm not sure. I don't remember, but it wasn't asserted. But regardless, even if you have to weigh the sufficiency of the complaint, it's a pure legal issue. The sufficiency of complaint would be reviewed de novo. The court can look at it and see that the complaint states a sufficient claim. Waste is where a life tenant fails in their duty to preserve the estate for the benefit of the remaindermen. The complaint pleads all of those legal requirements, and it has very detailed facts supporting those conclusions with an expert affidavit showing that, an expert report showing that it was neglected. And on the issue of the denial of summary judgment motion, it was based, as the court already pointed out, it was based on a factual issue. It wasn't based on the claim somehow being legally defective. There would have been no chance if Ms. Charter moved for dismissal under Rule 12b-6 for failure to state a claim. There's no chance that she would have prevailed on such a motion. And the fact that the church didn't receive summary judgment in its favor doesn't mean that its complaint failed to state a claim, not because it was on a factual issue. And on the issue of the affirmative defense, they make an argument about the statute of limitations. That's an affirmative defense. It's a facts-based claim. They lost that ability when they were defaulted. They would have needed to have shown that the plaintiff knew or should have known about the waste 3 years earlier. There are no facts indicating that. The facts indicate that my client received that report from its expert demonstrating waste 3 months before the complaint was filed.
All right. Seeing no further questions, thank you. We'll take it under advisement. Thank you. And our sixth and final case for the day is number 22P346, Matthew Haney versus MASHPEE Wampanoag Tribal Council, Incorporated, and another.
Thank you, Your Honor. As a Paul Revere for Matthew Haney, trustee of the Gooseberry Island Trust, to the obvious question,
Just a second, Mr. Revere. We're just going to take a minute so our clerk can reset the time. Okay.
Okay.
Thank you.
In answer to the obvious question, I asked for this. I had to come up for the CAPE. I said, can we do this on the same day? So, in any event, no one was doing anything to me I didn't ask for. This is actually a much more interesting case. It involves an island in Pompanesett Bay in Mashpee that is completely surrounded by a shellfish grant, which is held by the Mashpee Wampanoag Indians. The issue is whether an action can be brought against them relating to this shellfish grant, or whether the Mashpee Wampanoags are exempt under the concept of sovereign immunity. My client, I filed this one this time, filed a narrowly tailored complaint addressing essentially property issues. One is trespass, although it's to a large extent, where the grant is. A second is declaratory judgment as to the location of the grant. And then the third and fourth grants are private and public nuisance related to the operation of the grant.
Mr. Pierre, can I just jump right into your first argument? You cite a 10th Circuit case for the proposition that there was waiver here based on the license that they obtained, the fishing license, right?
Correct.
And as I understand it, in that case, there was explicit consent language, right?
Okay. I believe
so because as I understand the case law is pretty clear is that explicit waiver is required. The case you cite for the proposition that there was waiver here involved explicit consent or waiver. Where is that in this case?
I believe the case you're citing to is the Caddo Nation
versus Oklahoma. Yep.
Versus Oklahoma, where there was an express contract saying.
Right.
Okay.
Where the tribe consents to accept jurisdiction, et cetera, et cetera, et cetera.
Okay. In this matter, the waiver, well, it pulls into the second in rem, or movable property, but essentially the waiver is they accepted a license that said they would operate the property in a manner that, or excuse me, the shellfish propagation license in a manner that would not impair with the rights of others. That's in the...
All right. So but that would be implicit waiver, not explicit, correct?
Well, it would be implicit, but at the same time, you know, it's a waiver, an actual waiver of them doing it by taking the right to a government benefit, just like the Caddo Nation.
But just so we're identifying our terms, explicitly waiving something says is I hereby waive it, or I hereby consent to this, correct?
Yeah. There is no
and
document.
that's not here.
There's
and then
no.
so this would be then implicit waiver by their behavior or by what they did and engaged in accepting this contract or seeking this contract.
I see
or license,
that.
right? Is there any authority at all that you can point to that says that sovereign immunity for an Indian tribe can be implicitly waived as opposed to explicitly waived?
Well, there's also, if you look at it, the Puyallup case involving fishing rights out in Washington State, which says natural resources laws do apply to Indian fishing rights. And in this matter, we're basically talking about fishing. It's it's more actually like agriculture, but it's shell fishing in the area, an exclusive right to do that, to bar other people from it, to accept the benefits of treble damages if someone takes your shellfish there. So natural resources laws fall into an exception from the rule of
Who
requiring.
enforces those?
Generally, the state does.
Right. Do you have any, again, authority to suggest that a private citizen can go, if I don't like what my neighbor is doing and they're putting out their waste in a way that I don't like and that I feel is poisoning my garden, do I have any right of action on that basis? May have something else, but do I have anything on an environmental that I can raise that they're violating some environmental statute?
Well, I know this one, but I can't give you the site off the top of my head. There's a 10-citizen provision of Massachusetts, actually 10 resident of Massachusetts, to allow you to bring a private action for violation of environmental law.
Okay.
In that matter. So there is specifically in that. But we have here accepting this license, and as I say, the primary, I think, important argument that has never fully been addressed by the U.S. Supreme Court is this issue of the immovable property exception. Now, this involves the fun issue that continues to take up lots of time in my life as to waterfront law. Here in Massachusetts, unlike any other state, or actually Maine gets it too, a private property owner owns to the mean low water mark. That was finally set together recently. Basalt says that you cannot license land that's in private tidelands. This matter, we have this property dispute, this count number 2 for declaratory judgment, is where are the boundaries between this? What specifically, what is within the rights of the Wampanoag and what is not? The in rem property exception is put forth in a few cases. I think my favorite case is actually the state of Georgia v. Chattanooga, where the state of Georgia, quite interestingly, owned land in the state of Tennessee and was said you don't have a sovereign defense because property ownership is not a sovereign function. Here, we are talking about issues. There were 3 parts to this complaint. One was trespass, but it's about they're putting things on our property as part of the shellfish propagation license. 2 is where is it located, and 3 and 4 are nuisance claims out of the operations. I think one of the criticisms I have of Judge Perino in this matter is that the judge just found sovereign immunity across the board, but didn't really look at the immovable property exception or the in rem nature of this claim and address whether each of the claims is subject to it or not.
Can I ask, excuse me to interrupt, I don't mean, but can I ask on that issue, on the immovable property, the in rem issue, there is no case, and you don't cite it, I don't believe, that says that it applies to tribal, Indian tribes, right?
No, there's not a case, but I cite
and there are cases, though, that say, in the absence of that, leave it to Congress. The courts shouldn't inject themselves in that area, right?
Right, but I think there's...
So what are we, who are we then to say, we the appeals court, to say, well, we're going to create an immovable property right that applies to a sovereign Indian tribe?
Well, I think as Judge Thomas said in his dissent in Lundgren, he said it was Hornbook law before there were Hornbooks, which is...
But that was a dissent. And any immovable property that exists, immovable property exception, excuse me, has been recognized only in the circumstances of states or foreign sovereigns, not in the case of tribal sovereigns. Is that correct?
Correct. I cite to...
So this would be a substantial extension.
Well, that's why I cited to Judge Thomas and Judge Roberts, because in the Lundgren case, the immovable property exception, they felt was brought up too late. Judge Roberts suggested it should be addressed in the first instance by the Washington Supreme Court, and I cited to that in my record. So I think the issue is open as to Indian tribes. I also think it's an extremely important issue to the Commonwealth and to the country as a whole. There become issues of whether a member of an Indian tribe can transfer his property to the tribe, and then suddenly, can you tax that property with property taxes? Can a bank foreclose on that property? We have non-judicial foreclosure in Massachusetts, but there are multiple issues. If the tribe is accepting the benefit of these property rights, and that's to a large extent what I believe the shellfish license should be considered to be, it accepts the burdens of those. I mean, one of the classic examples I give is a tribe can purchase a piece of property. There's no issue they can purchase a piece of property. What if they have a dispute as to where their border is? Can the tribe just assert that they own more land and there's nothing that can be done about this by the landowner? To trespass, to move? I think the immovable property exception is an open issue. And as I say, the complaint was tailored to try to address these issues. As I point out in my brief, my clients and the Wampanoags have been at it for years. The Wampanoags use the courts continuously to try to block my clients' attempts to develop the island. And they say, we can do this because we control this land here. But at the same time, we ask the court to litigate, to look at the issue of how they control the land, where is this land they own, and their answer is sovereign immunity. In fact, if you look at the record closely in this matter, this claims that are set forth in this complaint were attempted to be added as a counterclaim in a certiorari case regarding a natural wetland resource delineation because the Wampanoags brought that issue. The court declined to allow that amendment in that matter and said, but, well, we're doing it without prejudice. You can file a secondary case. So my client attempted to bring it into a matter as a counterclaim. And there's one of the words, I like it from the matter, the word transmogrify is in one of the case that if you can't bring a counterclaim against an Indian tribe, then it becomes, we can win cases, but we can't lose them. My clients attempted to address this property issue in a matter where the shellfish propagation license was used as a sword, okay? Now the Wampanoags want to use sovereign immunity as a shield to my client trying to bring the same sword. This is a land issue, okay? It is subject to it, and this is not trust lands. This is not like down in Taunton. This is not an Indian reservation. This is actually Commonwealth lands, as anybody who's delved into Chapter 91 knows. The Commonwealth owns the lands below mean low water. The Commonwealth gave a right to exclusively shellfish in this area to raise and grow.
So there's no dispute over who owns the flooded tidelands at issue, whatever they may be.
Right. My client owns to mean low water.
Right.
But is set forth in the complaint, which those allegations, this was a motion to dismiss, need to be taken as true. There are cages and floats that are on private tidelands. They can't be licensed to do so under PASALT. The only alternative my client has left is to continue to go after individual members of the tribe for their actions working for the tribe.
What about enforcement action by the license issuing entity? I realize that's not in your client's control, but it's still a remedy that's available if the tribe is doing something it shouldn't be doing under the license.
I don't want to really get outside of the record, but I think my brother will agree that we have asked for a Chapter 91 determination of applicability as to cages and floats and location. So there has been, that question has been asked, but it's not been acted upon.
But one of the reasons I asked whether there was a dispute over ownership here is that to the extent the immovable property exception's been recognized, it exists to resolve disputes of ownership rather than use. Is that accurate? And what we have here is a dispute over use?
We have a dispute as to whether the location, whether they've been authorized to do actions on here. Trespass relates to actions on our property.
Right, but that's use, that's not who owns it. Is that accurate?
I think the Wampanoags would say that they have the right to go on our property.
They say they own the property?
They would say that they have both Aboriginal rights to be there and rights to do shell fishing in that area.
But I didn't hear you say they have rights to own it, or they claim to have rights to own it. So as far as the immovable property exception goes, even if it exists, it wouldn't seem to be applicable for that reason.
Well, I think part of those statements, one of my favorite things in law school was when you said, property is like holding a bundle of sticks, and all I could think of was the Led Zeppelin album. But are we talking about ownership? We're talking about what stick do they have in that area, okay? And I think that is the dispute between the parties. Thank you.
Thank you. Mr. Loeb.
Thank you, Your Honor. Good afternoon, Your Honors. My name is Jeffrey Loeb. I'm accompanied today by my associate, Ashley Berger. We represent the MASHPEE Wampanoag Indian Tribe. Let me start with just from a terminology standpoint, and to some degree one of Justice Sachs' questions about the immovable object exception raised that. We're not talking about sovereign immunity. We're talking about tribal sovereign immunity. That's more than just an additional word. That is a different term. That is a term of significance. It is, quite frankly, also a term of art. There's minimal case law in Massachusetts on this. I think the Akina case that's in the pleadings, I think that's really it on the issue of sovereign immunity. There's not a lot out there. The cases are out there that are federal. Coming to some of the questions that Justice Brennan was asking, absent a clear waiver, suits against the tribe are barred. There is no clear waiver here. There is nothing. There is really no suggestion. This isn't Caddo. This isn't St. Regis. There's a license. That license is not a waiver. There's not a contract. This isn't a quasi-administrative proceeding where there was they talk about a little bit in St. Regis. There is no waiver. The litigation that's referenced isn't a waiver. What the case law talks about is, for there to be a waiver in litigation, we have to be talking about mirror image. It's not a situation where you can't. And the analogy that's discussed, because the Supreme Court even went so far as to say, even if it's a compulsory counterclaim, that's barred. Think about the statute of limitations context, say in a tort and contract situation, where somebody brings a contract claim 4 years after the relationship is over. The other side might want to bring a tort counterclaim. That's barred by statute of limitations. Doesn't mean, however, under our law, they can't bring it. They can bring it and use it as a set-off. That's the same concept that we have here from a litigation waiver standpoint. The cases that were out there are not this issue. In fact, one of the cases actually bubbled up to you, the 2017 340 case, which was the case where Mr. Haney was the plaintiff that's referenced in the pleadings, actually came up here, and it's 2019 P 1395. That was a case that he brought against the DEP. My client was named because we're in a butter. We're there. We weren't bringing litigation. The other case was a certiorari matter that we brought. That's the 1872 CV 539 matter, where they attempted to intervene, but keep in mind, it's a certiorari claim that's limited to a review of the administrative record. That's it. That's not a waiver. That's not talking about anything having to do with the issues in this case. Then we get to the immovable property exception.
That was the Wampanoag's challenge to a decision of DEP, was it, or a local licensing authority, that certiorari action?
We had brought an action questioning whether or not something appropriate had been done, and then actually we dismissed it.
Right, but against who?
Not against Mr. Haney.
Right,
Mr. Haney
certiorari
tried
claim, I assume against some governmental entity?
against the town. It was against an issue within the town.
Okay.
Mr. Haney attempted to intervene. The court allowed him to intervene over our objection, saying he doesn't really belong here, Judge.
Had he been a party to the administrative proceedings?
Not that I understand, Your Honor. I wasn't involved in that, so I'm limited to the record, but not that I understand. Okay. Then we get to the immovable property exception. And this is why I began where I did by referencing tribal sovereign immunity. The immovable property exception exists, and in fact it exists by statute, by federal statute, as it relates to traditional governmental entities. It does not exist as it relates to Indian tribes. It is, with all due respect to this court and to any court, not for the courts to create an exception to the concept of sovereign immunity. The case law is clear. It is for Congress to do so. This exception does not exist. Now, as the trial court judge went through, it doesn't apply in this case anyway. But the issue for me before this court is that exception doesn't exist. That's not proper. That's not an argument that can be made. There is no legitimate legal basis for that. Finally, there is no case law. There is no suggestion of any case law. And the court asked, the panel asked, on this concept of a private right of action. In some way to try to enforce environmental law. And Attorney Revere referenced some of the case law out in Washington State. And I would, it's not in our brief in this case. You may have seen reference in one of the footnotes to the forfeiture proceeding, the claim for $300 or whatever it is. It's actually in our brief in that case. The United States v. State of Washington, which is 520 F. 2nd, 676. It's a Ninth Circuit case back from 1975. What the court there talked about was, yes, the government can take steps with respect to environmental, but if there are alternative means and methods of reasonable and necessary conservation regulations available, the state cannot lawfully restrict the exercise of Aboriginal rights of fishing. Aboriginal rights happens to be a term of art. Native Americans have the right to fish and fowl for sustenance. So that even if we have a situation where, you could say, okay, the government, there's clearly no private right, and even the law across the country is that even at a governmental level, restrictions. So there is absolutely no basis for this individual landowner, and there is no question, when the court takes a look, there has been a long-running battle between Mr. Haney and my client, the town, various other rebutters. Be that as it may, as to this case, these issues, the trial court was absolutely correct. These claims are barred by sovereign immunity. Happy to answer whatever other questions the court has, or I'll rest on the brief and what I've said this afternoon.
Seeing none, we thank you both for your arguments. That concludes our proceedings for today. I want to thank our court officers and our court staff for their assistance, and we are adjourned.